Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Glazer, Mr. Scheck. People represented by Mr. Darden and Mr. Goldberg. Jury is not present. Counsel, anything we need to chat about before we invite the jurors to join us?
We wanted to discuss the issue of the failing test yesterday afternoon. And
All right, let's do that at the conclusion of the cross-examination because we're into a different section now. All right, Deputy McNair, let's have the jurors, please.
Won't take that long. I noticed that during Mr. Fung's cross-examination, there appeared to be reactions coming from the audience. I can't tell exactly where they're coming from, but they are clearly audible. And I'd ask that the court try to put an end to that. I don't think that's...
There were two rather short reactions to two sections. That's correct. All right, but they were brief and they ended immediately without any action by the court.
I just asked the court to admonish the audience. There should be no noise, no reaction during the examination of any witness.
All right. I think the court's order is already in place. And I think the audience is aware of their obligations. All right, let's proceed. All right, let the record reflect we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. Mr. Fung, would you resume the witness stand, please? All right, good morning, Mr. Fung.
Morning.
You're reminded you're still under oath, sir. Mr. Fung is undergoing cross-examination by Mr. Scheck. Mr. Scheck, you may continue and conclude your cross-examination.
Thank you, Your Honor. Morning, ladies and gentlemen of the jury. Morning, Mr. Fung. How are you today, sir?
Morning.
Mr. Fung, just to return briefly to one point, you recall that we discussed Barry Fisher's book, Techniques of Crime Scene Investigation.
Yes.
And you indicated that you were familiar with at least one edition of this book.
Portions of one edition, yes.
And that you had considered this text in the formation of your opinions as criminalists.
Yes.
Overruled.
I'd like to call your attention, sir, to passage that I found yesterday. With respect to Fisher's views on the collection and preservation of bloodstains. And I call your attention to the first paragraph here on page 227.
All right, have you shown that to counsel?
I think he has the book.
Certainly. How do I take this opportunity? Mr. Fung, you can read the paragraph, see if you're familiar with that.
What page, counsel?
227. Robertson. Mr. Fung, you agree that this is a section in Fisher concerning the collection and preservation of bloodstains.
Yes.
And Fisher states that of all the common types of...
Your Honor, I'll object. There's no evidence that he read this issue.
Foundation objection. Sustained.
All right. Are you familiar with this passage in the Fisher book in the edition that you read?
I don't recall it.
All right. Do you recall in the edition that you read anything that Fisher said with respect to the fact that it's a certainty that wet or damp bloodstains packaged in airtight containers?
Sustained. No, there's a foundational objection.
Okay. In the edition that you read, do you recall Mr. Fisher offering a view as to whether or not wet bloodstains ought to be packaged in airtight?
Sustained. Mr. Fung, in your reading of this book, Barry Fisher's book, are you familiar with this particular section regarding the collection of blood evidence?
I don't recall reading this particular section.
All right, did you review it here just now?
Yes, I did.
Did it appear familiar to you at all?
I've read similar types of things before, but I'm not sure it's from that book.
All right, are these materials that you relied upon in forming your opinion, expressing the opinions that you've given in testimony so far?
Yes.
Proceed.
Do you recall in the edition of Fisher that you read whether Mr. Fisher indicates that it's a certainty that wet or damp bloodstains packaged in airtight containers such as plastic bags will be useless as evidence in a matter of days?
I don't recall that, but that's what it says in this book.
And that any type of preservation technique that hastens putrefaction should be avoided?
That's what it says.
And that would be, putrefaction would mean degradation.
Yes.
And that thus storing bloodstains that are still damp in airtight containers or in a warm environments will accelerate deterioration of the specimen.
That's correct.
Conversely, an air-dried sample stored in a paper bag at room temperature or better under refrigeration will retain its evidentiary usefulness for a significantly longer period of time.
That's correct.
Do you agree with Mr. Fisher?
Mr. Fisher is referring to final packaging in that section, and I do agree with that.
Well, where in this passage do you see any reference to Mr. Fisher saying that his admonition against using plastic or airtight containers only applies to final packaging?
Well, in this one phrase here, it says, will be useless as evidence in a matter of days. That, to me, means that that would be final packaging.
In the next paragraph, does not Fisher states, once blood evidence has been found, it must be collected and preserved in such a manner to achieve maximum benefit. All too often, improper collection and preservation of this type of evidence make the crime laboratory's work difficult and sometimes impossible. Very next paragraph.
I did collect it and preserve it in a manner to maximum benefit by putting it in plastic as an intermediate step to prevent contamination.
Well, does not Fisher indicate in this passage that to maintain the maximum benefit, one should attempt to air dry the samples at the scene?
I'll check that states the others.
Sustain, reread the passage.
Does not Fisher begin this whole section by saying, of all the common types of evidence found at crime scenes, blood is perhaps the most fragile. The value of bloodstains for typing begins to diminish almost immediately. Yes?
Yes.
The stability and utility of bloodstains varies from several days to months depending on the blood grouping system sought.
Yes.
Naturally, proper preservation procedures improve the chances of determining blood types.
Yes.
So, from reading this passage, would you not agree that Fisher is communicating the fact that one should avoid at any time putting wet bloodstains in plastic containers.
I don't think that's what he's saying there.
So your position is that it's okay to use plastic bags to package wet bloodstains as long as it's temporary.
What do you mean by temporary?
Well, what do you mean by temporary?
Counts as the one that needs to.
How long?
Raise the question.
How long do you think it would be sound to keep wet swatches we're talking about, in plastic containers?
There would be many factors that would go into that.
Would you not agree that the best practice would be to let the samples air dry at the scene?
No, not necessarily.
Would that not be the way to achieve the maximum benefit in terms of preserving the evidence?
Not necessarily.
Now, you began collecting the blood drops at Bundy at what time?
Approximately 11 o'clock, 11:30, around then.
You began putting them in plastic bags around 11 o'clock, 11:30, you and Miss Mazzola.
Approximately.
And you put those plastic bags inside coin envelopes.
Yes.
And you put the coin envelopes eventually into a large brown paper bag.
Yes.
And you put those brown paper bags on the floor of the crime scene processing truck at some time that afternoon.
Yes.
And the sun was shining.
Sun was shining.
And it was hot inside that truck.
There were periods when I went out to the truck to make sure it wasn't getting too hot.
But, well, by what means? By opening the doors and waving your hands there?
Periodically, I would go to the truck to see if it was getting hot or not.
Well, it was getting hot, wasn't it?
It was getting warm.
And you did not begin the process of taking those wet bloodstains out of those plastic bags until around 6:30 in the evening.
Yes.
So you had those wet stains in the plastic bags from, I guess your estimate is somewhere around 11:30 in the morning until 6:30 in the evening.
Those stains is overly broad.
Sustained. Raise the
It's
question.
the blood swatches that you collected at Bundy.
Yes.
So let's see, that would be something on the order of 7 hours.
Yes.
Is that your interpretation of temporary storage?
My goal was to get the blood I collected into the drying state by the evening, and I accomplished that goal. And I feel that is that was the proper way to collect and preserve that evidence.
Is there a refrigerator in the crime scene processing truck?
There is one, yes.
Didn't use that.
No. That is because the refrigerator it stops working after several hours. It doesn't keep working.
Is that a
continuously.
defect in the refrigerator or
It's just,
non-functional refrigerator
well,
in the crime scene
it does
truck?
work, but it's been
Excuse me, counsel. And Mr. Fung, let him finish asking the question before you start to answer. Mr. Scheck, let him answer the question before you start discussing it with him.
Oh, I'm sorry.
All right?
Is that
Correct,
a
madam?
non-functioning refrigerator? Is that what you're telling us?
It's been my experience that after several hours, the refrigerator doesn't kick on anymore.
Isn't it your responsibility as a criminalist under the rules to make sure that the equipment is functioning in the crime scene processing truck?
As best I can.
Don't you keep a log that when you check out the truck in the morning?
No,
Isn't there a crime scene processing? Yes. Isn't there a crime scene truck supplies checklist?
I believe there is one, yes.
You've seen it, haven't you? All right, ask that these 4 pages be marked defendants next in order.
Mrs. Robertson? 1095.
Have you seen this form before?
I have not seen this form before.
You've never seen a form entitled Crime Scene Truck Checklist?
I have not seen this particular form before.
Have you seen one like it?
I've seen inventory of the items that are supposed to be in the truck.
And before you take out the truck, at some point, do you do an inventory to make sure that all the proper equipment is in the truck?
The crime scene processing unit is assigned that task.
All right, so it's your understanding it's the responsibility of the crime scene processing unit to see that all the proper materials are in the truck.
Yes,
And it's their responsibility to make sure that equipment such as the refrigerator is working.
yes.
And had you had any discussions with any members of the crime scene unit about the fact that the refrigerator, I guess as you've told us, can't be relied upon to function over a few hour period of time?
When the truck, the battery just doesn't work after a long period of time. And it kicks on, but kicks back on when the truck is started again.
Now, Mr. Fung, you are now a criminalist 3.
Yes,
And when you started at the LAPD crime lab, I take it you began as a criminalist 1.
yes,
And to get from a criminalist 1 to a criminalist 2, did you have to take any oral or written examinations?
no,
To get from a criminalist 2 to a criminalist 3, did you have to take any oral or written examinations?
yes.
And what were those, sir?
There was a written examination and regarding laboratory type functions and an oral given for that position.
And did any of the questions on your oral or written examination to become a criminalist 3 include materials that are contained in the handouts that constitute your manual?
Well, it states the evidence is to
Overruled.
Were there any questions? Let me see if I can get your question properly.
Sure.
Are you asking me if any specific questions in the written or oral pertained to that manual?
Pertain to handouts that are contained in that document we discussed a few days ago that constitutes the manual?
It's the testimony given adopted.
Sustained.
You told us during cross-examination that you were aware of the existence of a set of documents that constituted a manual that you said was not yet in effect.
Yes,
And you looked through the binder that contained these written materials.
yes, I did.
All right. My question to you, sir, is when you took the examination to become a criminalist 3, oral and written, did it contain questions on the materials that you saw when you looked through that binder that is the manual?
I don't recall any specific questions related to that.
In other words, any of the documents that you saw in this manual that you say is not yet in effect did not pertain to the documents in the manual?
I don't recall any specific questions that related to that manual. Or
Do you recall?
adopted manual.
I'm sorry. Are you finished, sir? My apologies. Did you recall any questions in your examination concerning the collection of biological samples such as blood for purposes of subsequent genetic or DNA testing?
I don't recall any.
Do you recall any questions on your oral or written examinations with respect to keeping records for purposes of chain of custody?
No.
And incidentally, Mr. Fung, that refrigerator on your crime scene truck, is that used to keep soft drinks?
No.
Now, are there records of the courses that you took at the LAPD laboratory?
Are there records?
Yes.
There's a statement of qualifications.
But to your knowledge, in the laboratory, is there any ongoing set of records that's inputted into a computer system or kept in written form as to which courses you or any of the other criminalists take?
I'm not sure if there is or not.
Now, in terms of discussing records for purposes of chain of custody, you are required, are you not, to keep all the original records that you fill out during the course of a field investigation in the laboratory?
I wouldn't say all of them, no.
Well, aren't you supposed to keep in a place that's accessible to supervisors and other criminalists in the laboratory a set of documents that represent the original records that you fill out during the course of a field investigation?
Basis to supposed to.
Correct. Rephrase the question.
To your knowledge, is there a requirement that criminalists are supposed to keep original records, crime scene check, such as the crime scene checklist, in the laboratory so that supervisors and other criminalists can get access to them?
Still good.
Oh, well.
The crime scene checklists, when completed or when the person is done with the crime scene checklist, is filed in an area where that type of information is stored.
Right. And that, when you say those records, we're talking here about the original documents.
Talking about the crime scene checklists.
But
yes.
when I say original documents, I mean the actual documents that were filled out by you and/or Ms. Mazzola in this case at the scene and subsequently.
At this point, it's unintelligible.
Oh, well.
Could you repeat the question?
Sure. These documents that you've told us are filed and stored at the laboratory. They are the original documents that were created by you or Ms. Mazzola in this case.
There are original documents, yes.
And you're aware, sir, withdrawing. To your knowledge, have those original documents, to the extent they could be found, been produced here in court at the defense, request of the defense?
To the best of my knowledge,
You're aware that we've requested that?
yes.
And you're aware, sir, that we had these documents reviewed prior to your testimony by a document analyst?
I heard something to that effect.
Now, in the production of these original documents, was there not a document for which you could not find an original?
If you could show it to me,
My recollection, I think the prosecution might have introduced a copy of this document. But just for the sake of clarity of the record, I'll ask that this document be marked appendix next to it.
1096.
Do you recall seeing this document that has on it an indication that it is L-16 or laboratory page number 16?
yes.
All right, you've seen this.
With regards to this document?
Yes.
All right, report, please. All right, thank you, counsel. Proceeds.
Do you recognize any of the handwriting on this document?
Yes,
And whose handwriting is it?
it's mine.
And did you not look at this document and refresh your recollection as to what you did with samples on June 14th and on June 15th when you were testifying on direct examination?
I may have. I don't recall if I did or not.
All right. This document is undated.
That's correct.
Do you know when you filled in this document?
I don't recall when I did, no.
This document refers to what you did on June 14th when you released certain items to criminalist Yamauchi.
Yes,
And the item numbers here refer to photo identification numbers.
The numbers refer to photo ID numbers, yes.
And number 117 here would be referring to item 52, or a blood drop at Bundy.
Yes,
And item 115 would be another blood drop at Bundy,
yes,
as would be 114, 113, and 112.
yes,
And 107 and 106 were red stains you took in an effort to get exemplars from the victims at the scene, correct?
yes,
And by exemplars, we mean samples that you thought would almost certainly be the blood of each of the victims.
yes,
And then the next notation here concerns receiving from Mr. Yamauchi on June 15th a blood vial made up of the blood of Nicole Brown Simpson.
yes,
And then the next notation refers to June 15th and a series of now what are item numbers.
yes,
So in the last entry here, you're now not using photo ID numbers, you're now using item numbers.
I believe the photo ID numbers and the item numbers are the same in those cases.
And these, you're referring here on June 15th to turning over to Mr. Yamauchi samples 23, 34, 25, 31, 33.
Yes,
Those are samples from the Bronco.
let me check. Yes,
And you refer here to giving those to Mr. Yamauchi, return same night after sampling.
it says return same right after sampling.
Return same right after sampling. Now, is this page a contemporaneous record that you made as these events were occurring?
I don't know if this was contemporaneous or not. I may have copied this onto this page from a scrap of paper or something.
Would you not agree, sir, that for purposes of keeping records, when you're trying to create a chain of custody, that the proper procedure is to make out records as you are performing the actions, turning over the samples?
That is one way to do it.
Wouldn't that be the most reliable way to do it?
That is one way of doing it.
Isn't that the way that you were taught to do it?
That is one way, yes.
Would you not agree that in terms of creating records for purposes of chain of custody, that it is not a particularly reliable thing to make out a record of what you did on an undated piece of paper?
It's argumentative. Just
There's no date as to when you filled out this report.
It's correct.
No date as to when you made entries about turning over these pieces of evidence.
The dates are written in the information.
But this document could have been written weeks after these events.
Yeah, it wasn't weeks.
Well, is there any way from looking at this paper that you can tell us when you filled out this document?
No,
And you don't have an original of this document, do you?
I believe I found it and turned it over to Mr. Matheson.
The original?
I believe so.
When did you do that?
A 2 weeks ago, maybe 3 weeks ago. I don't remember.
You certain of that?
Yes,
Well, it's vague as to what he's certain about, but he turned it over.
Well, let me ask you, are you certain that you turned that over to Mr. Matheson 2 or 3 weeks ago, the original of that document?
Something like that.
Where did you find the original?
It was in here.
It was in your, what you're referring to now is what?
It's my notebook.
All right, so that's your personal notebook.
Yes, it is.
And that contains copies of these various crime scene checklists and other documents relating to this case.
This contains that and other things, yes.
Yes. May we approach for a minute?
I think this is something we can take up when we conclude with this.
Well, I just want to make a brief record on this point right now.
The record exists. Proceed.
To your knowledge, was the original of that document turned over to the district attorney's office?
I don't know if it was or not.
Now, your reports with respect to field investigations are supposed to be reviewed by a supervisor.
Yes,
And prior to approving and signing these reports, the supervisor is supposed to inspect all case notes, photographs, et cetera, to ensure that your reports are accurate and complete.
yes.
And what is a field investigation note package?
That would contain field investigation notes and a proctor report.
So that would include the crime scene checklists that we've been discussing during your testimony.
Yes,
It would include the vehicle search tech checklists that we've been discussing during your testimony.
yes,
It would include the evidence collection sheets that we've been discussing during your testimony.
yes,
It would include the diagrams that were drawn on the back of some of these pieces of paper that you and Ms. Mazzola made during the course of your investigation on the 13th and the 14th.
yes,
And isn't it required that the field investigation note packages must be submitted prior to filing at the lab to the supervisor of the trace analysis unit for review?
At the time, there was no trace analysis supervisor.
All right? What supervisor was in charge of reviewing your field investigation note package in this case?
Overruled.
My property reports were reviewed by Mr. Matheson.
What about the crime scene checklists? Who reviewed those?
I don't know.
To your knowledge, were they given to anyone for review?
Copies were given to lab management.
Are you aware that deficient note packages are supposed to be corrected and supplemented by involved employees and subsequently filed and stored?
As soon as that gun evidence is raised.
I'm asking him if he's aware of that.
Overruled.
That has been a practice, yes.
And would that lab management include Michelle Kessler, the head of the laboratory?
She is the crime lab director.
And to your knowledge, was she reviewing your work in this case?
I don't know if she reviewed or how much of it she reviewed.
Was she discussing your work in this case with you in the week of June 13th to June 20th?
I don't recall if she did or not.
To your knowledge, did anyone at the laboratory in a supervisory position come back to you and point out anything that needed to be supplemented in your field note package?
Not that I can recall.
Now, ordinarily, when you book something at the laboratory, you go through certain procedures. Book an item of evidence.
Yes.
And this would include swatches that were collected from bloodstains
Yes.
and certain physical items of evidence, such as the glove and the hat that were collected in this case.
Yes.
And the ordinary procedure is that a DR number is bought by one of the detectives in the case.
Yes.
And after the DR number is bought, you can begin to book certain evidence in a place called the Evidence Control Unit.
Yes.
And the Evidence Control Unit is a certain room at SID.
It's more than just a room, but it is a section of SID.
It's a section of SID. And when you book an item of evidence in a case, what happens is that the people at ECU will stamp it with a date.
I don't know what they do once I give it to them.
Well, haven't you ever seen an item of evidence booked at ECU?
Yes, I have.
I mean, you do that all the time, don't you?
Yes.
And don't you recall that at ECU, when they get either a paper bag or an envelope or something of that nature, that they will put a stamp on it that gives the date?
I bring my evidence to property. I sign my name next to a register. The station officer or property officer reads the report, makes sure that they can book or understand what's on the report, and I leave. I don't stick around and see what they do.
So you've never noticed a timestamp on it?
I never have, no.
Have you ever noticed at ECU that they will put a barcode on the the packaging of the item of evidence when you turn it over to them?
I have noticed barcodes, yes.
And you're aware that when the barcode is put on the item of evidence, that item is then put into a computer tracking system.
I don't know how it works, but it is tracked by a computer.
Well, once an item of evidence is booked at ECU, are you aware of how criminalists at SID would then obtain that package for subsequent analysis?
Oh,
I know how I do it.
Well, you've worked in trace analysis.
Yes, I have.
And if you're working in trace analysis and you want to get an item of evidence that's been booked in a case, you have to go to the ECU.
When I worked in trace analysis, ECU was not in existence.
Have you worked in any unit where you have to go to ECU to obtain an item of evidence?
The unit I work in now, I occasionally have to go down and pick up items from ECU.
And when you pick up an item from ECU, the person at ECU has to take one of these barcode readers and hit a barcode of their own. Have you seen that?
Yes.
And you have a barcode, correct?
Yes.
And your barcode is hit with one of these light pens.
Or a tracking device.
Tracking device. And then the barcode on the package of evidence is hit with one of those light pens.
That's one of the steps.
And the purpose of those operations is to try to create some kind of tracking record as to the fact that you have gone to ECU to take out a piece of evidence for analysis.
It does make a record, yes.
And then when you finish your analysis, you would return it to the ECU, and a similar procedure is performed.
Yes,
And it is by that method that, to your understanding, items of evidence are tracked at SID.
that's one of the methods.
Now, with respect to the evidentiary items in this case, they weren't the ones you collected at Bundy on June 13th. They were not booked until June 16th.
That's correct. No, final booking was not until June 16th.
In other words, this process of taking the package with the barcode on it and handing it to the person at ECU was not done until June 16th.
I did not do that until June 16th because my property reports were not written or completed until that time.
But the point is, sir, that until June 16th, these items were not put into that computer tracking system at SID.
They couldn't be because the property report wasn't prepared yet.
They couldn't be because they had not yet been formally booked, or to use your phrase, finally booked.
They were not placed into ECU at that time.
And by placing them into ECU and having at least the barcode put on it, and the evidence tracking procedure begun, that's what's ordinarily meant by final booking, to use your phrase.
Final booking, yes.
On the evening of June 13th, the swatches from Bundy had been placed in test tubes.
Yes,
The swatches from Rockingham had been placed in test tubes.
yes,
They were put inside coin envelopes.
yes,
They were laid in a cardboard box top, laid down.
they were lit. It was more than one box top, but yes,
Those box tops were put in a cabinet in the evidence processing room.
yes,
That cabinet was unlocked.
the cabinet was unlocked. However, the door to
Was
the
the
evidence
cabinet
processing room
unlocked?
was
Wait,
locked.
wait. You need to let him finish the answer.
Well, I thought he did, and he
No,
was
he was-
volunteering, Your Honor. I
Well,
thought
then
his-
there's an appropriate motion, and don't interrupt me either,
My apologies. I'd moved to strike the last part of his answer.
as being non-responsive.
Yes.
Yes, granted. Jury is to disregard the last part of the answer. Proceed. Question was the cabinet locked or unlocked?
Was the cabinet locked, yes or no?
There is no lock on the cabinet.
When you received the blood vials from Detective Van Adder on December 15th, withdraw. My apologies. Got the wrong year, the wrong month.
Take a deep breath.
Okay. On June 15th, you received some blood vials from Mr. Yamauchi.
Yes,
A blood vial containing whole blood from Miss Nicole Brown Simpson.
that's one of the vials.
A blood vial containing whole blood from Ron Goldman.
Yes,
These vials, when you received them from Mr. Yamauchi, did they have blood streaking over the top of the vial on paper that was covering the vial?
I don't recall.
On the morning of June 14th, you came to the lab.
Yes.
You arrived around when?
Between 7:30 and 8.
And when you got there at 7:30, did you meet with someone?
Met with several people.
Who did you meet with?
I saw Criminal Mazzola that morning. Detective Lang. Criminal Yamauchi. And Mr. Matheson. To name a few.
I'm sorry?
To name a few.
Anyone else that you can recall?
Not that pertains to the case.
Well, just tell us who else was there, whether they pertain to the case or not.
It's irrelevant. These are pretty talked about.
Oh, there were many people in the laboratory, and I saw many of them.
This meeting that you had at around 7:30 occurred in the evidence processing room?
No. I'm not exactly sure where. Some of the... I saw Detective Lang in the serology unit.
So there's a separate room for the serology unit. It's a laboratory room.
Yes.
And that contains a separate freezer for the serology unit.
The serology unit does have a freezer, yes.
All right. And that's a separate room from this evidence control unit where items are booked, correct?
Where the booking process takes place, yes.
And after items are received in the evidence control unit, there's a freezer where they might be stored.
Could you repeat that?
The evidence control unit has a number of different places where items of evidence are stored.
Yes.
There are shelves where items of evidence are stored.
Yes.
There is a freezer where biological evidence is stored.
Yes.
There is a refrigerator unit where things such as whole blood vials that contain whole blood are stored.
Yes.
In this case, there was actually an ordinary kind of locker where certain items of evidence in this case were stored.
Are we talking about the evidence control unit or the
Yes.
evidence processing room?
Evidence control unit.
I don't know where the evidence was stored once I placed it into, put it into their custody.
But what I've just described is one whole unit where the final booking procedures take place, the evidence control unit. Right?
Yes.
Now there's a separate place called the serology laboratory.
Yes.
And in the serology laboratory, there is a separate freezer where items are kept when serologists are working on them.
I don't know what is kept in the serology freezer. I haven't worked that unit.
But you're saying that on the morning of June 14th, you saw Detective Lang in the serology lab.
He was there, yes.
Was he there when you got there?
I'm not sure.
He could have been.
He could have been.
And who else was with him, if anyone?
I don't recall.
So you had a meeting, the first meeting you recall took place in the serology laboratory with Detective Lang?
I don't know if it was the first, but it was one of the meetings.
All
But
right. Where else did meetings take place that morning at around 7:30?
Well, I can't say if it was at 7:30 or not, but I can tell you different meetings that occurred that morning.
If you can, sir, give us your best recollection of who you met with and where you met with them from the moment you arrived at the serology lab on the morning of June 14th.
So,
Sustain, rephrase the question.
Can you tell us who you met with and where you met with them when you first arrived at the serology laboratory on the morning of June 14th?
In the serology lab, Detective Lang, Mr. Matheson, and Criminalist Yamauchi were present.
And you had a discussion at that time? All
Yes.
of you? You discussed the items of evidence in this case?
To the best of my recollection, yes.
Detective Lang indicated which items he wanted analyzed first?
I don't know if he was involved in that, in specifying which items he wanted to be analyzed.
Do you recall Detective Lang indicating that he wanted the blood drops found at Bundy analyzed right away?
He may have said something to that effect.
And you took away from that conversation,
I'll make a motion to strike this answer is called for speculation.
Overruled. Overruled. So he may have said something to them.
do you recall whether Detective Lang was indicating with some urgency that he wanted the blood drops at Bundy analyzed right away?
It's asked and answered.
Overruled.
He wanted a priority put on it.
Did he want a priority put on the analysis of the Rockingham glove?
I don't recall if that was one of the items he specified or not.
Was there an agreement at that meeting as to what items should be analyzed immediately?
At some point in the morning, it was decided what items would be analyzed, but I don't know at exactly what time or if Detective Lang was present or not.
Did there come a time that you went to the evidence processing room that morning?
Yes,
Was that after this meeting in the serology lab?
yes.
And around what time did you enter the evidence processing room?
Approximately 9:30, somewhere in there.
Have you looked at any records to refresh your recollection as to when you might have entered the evidence processing room before you came to testify?
Yes, however, I don't remember the time.
Have you gone over these events with some care with the prosecution?
Yes,
A number of times.
I wouldn't say a number of times, but we have gone over it.
All right, around 9 or 9:30, you recall going to the evidence processing room.
It's the evidence.
Overruled.
Is that right?
That's about the time, yes.
And Ms. Mazzola was there as well.
I don't recall.
Well, was it about this time that you began to remove the swatches from the test tubes, you and Ms. Mazzola?
It was in that time frame, yes.
All right. What about the sneakers that Detective Lang brought on the morning of June 14th? Did you receive those in the evidence processing room?
No.
You received those in the serology lab?
To the best of my recollection, yes.
He had those with him in the serology lab when you arrived.
I believe so.
What about the Rockingham glove? Was the Rockingham glove in the serology lab when you arrived?
No.
When you went to the evidence processing room at around 9:30, did you perform some analysis on the Rockingham glove?
I didn't do any analysis, no.
Well, did you not remove a hair from the Rockingham glove?
Yes, I did.
Was that one of the first things you did? Was that the first thing you did when you got into the evidence processing room that morning?
I don't recall what the order of events was.
So you don't recall whether or not you removed the hair from the Rockingham glove before or after the process began of removing the swatches from the test tube?
They were done at different times.
But you don't recall the order.
No, I don't.
And at some point that morning, before you left to go search the Bronco at the print shed, you poured off some blood from Mr. Simpson's blood vial.
No.
Well, did you participate in pouring off some blood from Mr. Simpson's blood vial with Mr. Yamauchi?
No.
Did you give Mr. Simpson's blood vial to Mr. Yamauchi on the morning of June 14th?
Yes, I did.
Do you remember when you did that? In terms of the order of what withdrawn. Let's start it this way. Did you hand Mr. Yamauchi Mr. Simpson's blood vial in the evidence processing room?
I gave him the package,
You gave him the package.
the gray envelope, yes.
Was the gray envelope sealed?
Not at that point.
Did you reach in and take out the blood vial and hand it to Mr. Yamauchi?
I gave him the package.
Were you present when Mr. Yamauchi took the blood vial out of the package?
I don't recall if I saw him do that or not.
Now, at some point in the evidence processing room, Mr. Yamauchi began cutting samples out of the Rockingham glove.
I don't know that.
You didn't see that.
I don't recall seeing that.
All right, Mr. Scheck, I think this would be a good point to change court reporters. All right, ladies and gentlemen, we're going to take a brief recess at this time. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves, form any opinions about the case, allow anybody to communicate with you, or conduct any deliberations till the matter has been submitted to you. Mr. Fung, you may step down. We'll be in recess for 15 minutes. Back on the record in the Simpson matter, all parties are again present. Deputy McNair, let's have the jurors, please.
If I don't finish at 12, I can tell you precisely how much. It shouldn't be much. I'm going to try to finish at 12. I may not.
All right, let me
If
see
it
what's
would
going
only be a
on.
half hour left.
Are the jurors on their way? All right, thank you, counsel. Mr. Scheck, you may resume.
Thank you very much, Your Honor. Mr. Fung, just before we broke, we were discussing your activities on the morning of June 14th at SID.
Yes.
And you indicated at one point that you had refreshed your recollection by looking at some records with respect to where you were at particular times that morning.
Yes.
What records did you look at?
There's a card system in the laboratory that keeps a record of when people go in and out of certain areas of the laboratory. And those records are what I referred to.
You mean a computer printout of some kind?
Yes.
And Mr. Goldberg showed you a copy of that?
Yes.
Mr. Fung, I noticed that on direct examination, you were not asked whether Detective Furman showed you 4 red stains on the bottom exterior of the Bronco door on the morning of June 13th.
Sustained. It's not a question, counsel. That's testifying. The jury is to disregard that last question. Ask a question, Mr. Scheck.
Nice. Were you asked on direct examination, if you recall, about whether Detective Furman showed you 4 red stains on the exterior of the Bronco door on the morning of June 13th?
No, gentlemen.
As phrased, that's correct. Sustained. Ask him if the events occurred on June the 13th, not whether or not he was asked the questions. That's irrelevant.
Have you spent, in your preparation time with prosecutors, some hours discussing the issue of whether or not 4 red stains were seen by you on the morning of June 13th on the exterior of the Bronco door?
I wouldn't say hours. I wouldn't even say 1 hour. I wouldn't even say more than 5 minutes.
The issue, however, arose.
Yes.
Was there any discussion with you as to whether or not you should discuss the question of whether you saw 4 red stains on the exterior of the Bronco door on the morning of June 13th?
I don't understand that question.
Was there any discussion of whether or not you should testify on direct examination as to whether or not you saw 4 red stains on the exterior of the Bronco door on the morning of June 13th?
I don't know, or I didn't tell Mr. Goldberg, and he didn't tell me that he would be asking me those questions specifically.
So in other words, in your review sessions for your direct examination, you did not anticipate being asked that question on direct?
Sustained.
You testified at the preliminary hearing in this case on July 6th and July 7th.
Yes.
Prior to your testimony on July 6th, do you recall that Detective Furman testified on July 5th?
I know that he testified before me, but to the date, I'm not exactly sure.
Do you recall that prior to your testimony at the preliminary hearing, Detective Furman testified that he did not direct you or a photographer to take any pictures of 4 red stains on the exterior of the Bronco door?
I don't recall any of his testimony from the preliminary hearing.
Are you aware at this trial Detective Furman testified that he did show you 4 red stains at the bottom exterior of the Bronco door on the morning of June 13th.
That states the testimony.
Sustained.
Are you aware that Detective Furman testified at this trial that he directed your attention to 3 or 4 little marks, little lines, translucent red, on the door sill of the driver's door on June 13th?
I don't know what his testimony was.
No one told you from the district attorney's office that he testified to that effect at this trial?
No.
Did any detective tell you that Detective Furman had testified to this jury about showing you those 4 lines, the bottom of the Bronco door, before you came in here to testify?
No.
Did anyone at the crime lab tell you about it?
Assumes facts not in evidence, it also states the testimony.
Overruled.
No.
Your Honor, the counsel is going to read.
If you want to consult the testimony, it's at page 18550 of the direct.
Proceed.
Thank you, Your Honor. Okay, Mr. Fung, let me ask you directly. On June 13th, in the morning, did Detective Furman point out 4 red lines, red stains, to you on the bottom of the Bronco door?
I don't recall him doing so.
When you say you don't recall, are you saying it didn't happen?
I'm not saying that. I'm saying I don't recall if he did or if he didn't.
Right? If you had seen 4 red stains on the exterior of the Bronco door on the morning of June 13th, you would have taken a photograph of them, would you not?
That would depend, but I don't know. But that would depend on the circumstances.
Let's try these circumstances. You were pointed out a red stain by the door handle.
Yes.
You were photographed pointing to that red stain, correct?
Yes.
And you're the person that's supposed to direct the photographer during the collection process.
Yes.
You're supposed to photograph items of evidence of some importance that are pointed out to you by the detectives.
Yes.
In the circumstances of this case, if you had seen 4 red stains on the exterior of the Bronco door, would you not have directed the photographer to take a picture of it?
It would be likely, yes.
If you had seen 4 red stains on the exterior of the Bronco door, would you have not done a presumptive test on June 13th?
Possibly. If it was necessary, I would have.
If you had seen 4 red stains on the exterior of the Bronco door, would you have not swatched them?
I would possibly have swatched them.
If you had seen 4 red stains on the exterior of the Bronco door, would you not have included that observation in your reports for that day?
If I thought it was important to the investigation, I would have included it in my notes, yes.
Looking back at the circumstances of this case, would not those 4 red stains have been an important detail that you would have certainly included in your notes?
All speculation.
Oh,
From my perspective now,
Let's try your perspective then.
I don't recall my exact state of mind then, but I don't know exactly if I would have put it down or not.
On June 14th, you conducted this examination of the Bronco at the print shed,
Yes,
and you were looking for any evidence of blood in the Bronco.
I was looking for blood evidence, yes.
Red stains.
Yes,
You got on your hands and knees with a flashlight and examined the exterior area of that door sill.
I did examine the area of the door sill. I don't know if I was on my hands and knees.
Don't you recall a picture of you with the flashlight on your hands and knees looking at a red stain just inside the interior of the Bronco?
May have been squatting, but I wasn't on my hands and knees.
All right, squatting. All right, I'd like to display a picture now that shows the prosecution. I'd ask this be marked defendant's next in order, although I believe there may be a picture of it,
1097.
1097. Is this not a picture of you holding a flashlight, examining the door sill area of the Bronco on June 14th at the print shed?
I think in that particular photograph, I am indicating to the photographer where I want him to locate his shot, and that would be where the card is. I can't read the number from here.
Did you not examine the door sill area at the print shed on June 14th?
Yes, I did.
Mr. Harris, can we go tighter on the door sill area? Right where the door is opening?
Yes, 1097.
Mr. Fung, do you see 4 red stains on the door sill of that Bronco in this picture?
I'll object to it. You can see the exterior doors of the station.
Overruled.
It's washed out. The white area is very washed out. You can't even make any detail out in any of that portion.
Let me put it directly to you, sir. On June 14th, when you examined the Bronco, did you see 4 red stains on the door sill of the Bronco?
I object to counsel's tone of voice. I also object as this does not go to the area that was related in the testimony.
I object to that
Overruled.
objection. Speaking objection.
It is a speaking objection. Proceed.
My question to you, sir. On June 14th, did you see 4 red stains anywhere on the exterior of the Bronco door?
There were stains present, but I did not collect them.
It's your testimony, sir, that you saw on June 14th, at the print shed, 4 red stains on the exterior of the Bronco door.
That's not what I said.
Sustained.
On June 14th, did you see 4 red stains on the exterior door sill of this Bronco?
I don't know if I saw 4 red stains.
If you had seen 4 red stains on the morning of June 14th, would you not have directed the photographer to take a picture of it?
If they were heavy enough stains, then I would have, yes.
Is it your testimony that you saw 4 red stains on June 14th, but you didn't think they were heavy enough, and therefore you did not direct the photographer to take a picture?
There was quite a bit of blood, quite a bit of light staining around the driver compartment of the vehicle, and I only directed the photographer to concentrate on the heavier stains.
It's not my question. My question, sir, is it your testimony that you saw 4 red stains on the exterior of the Bronco door on June 14th, but you thought they were not heavy enough, and therefore you did not direct the photographer to take a picture? Is that what happened?
I don't know if there were 4 or not. The number 4 is the problem with the yes or no.
3 on the exterior of the Bronco?
I don't
On
recall the
June-
number.
You don't recall?
Ms. Clark. That's twice
Please
for this witness.
Please repeat it.
Are you
Repeat the
saying,
question.
my apologies, are you saying that you saw 3 red stains on the morning of June 14th?
It's hard.
Overruled.
No, I'm not saying that.
Are you saying you saw 2 red stains?
I do remember that there was either a stain or 2 stains that were very light along the sill area that I did not collect.
Can you point out for us, using the Elmo, the area in this picture where you claim to have seen some red stains on the morning of June 14th?
It seems to fact on evidence that it would be on this.
Sustained.
Well, you were just making reference before, in answering my question, you were looking towards the monitor and indicating something about an area, were you not?
I was trying to find some detail in the photograph that could help me, but it was really looks fairly washed out to me.
Well, can you just show us the area where you're claiming to have seen red stains on the morning of June 14th?
To rephrase the question, please.
Could you show us the area in this photograph where you saw red stains on the morning of June 14th?
I'll have to make several assumptions in doing so in the photograph.
Well, does this photograph depict the area?
It does, but it does not show sufficient detail for me to point out specific areas.
Well, can you just direct the pointer to the area as best you can?
As best I can, making some assumptions.
At this point, there's no foundation for the witness's testimony.
Overruled. He said it depicts the area.
Speculation.
Go ahead.
Up higher. Okay, slowly to the right. Down lower, slowly to the right. A little higher in that area there.
Okay. Can you direct it in a circle? How far did they extend?
No, that's not the area I indicated.
Okay. Let's try again.
Right? Okay, a little lower there. Nope, a little higher. Okay, and now just maybe a little bit more to your left. A little bit more to the right. Okay, now you're covering it. That's just about the area.
Okay. Can we print that and make that appendix next in order?
1098. 1098, Mrs. Robertson? 1098, next in order defense. Thank you.
Now, did you report to anyone seeing a red stain on the exterior door of the Bronco on the morning of June 14th?
No,
Did you make any notation of it?
no,
You went back to the Bronco for a visit on June 28th.
yes,
Did you see the red stain on June 28th?
I didn't look for it.
You went with another criminalist. Mr. Morakovo, am I pronouncing that?
Master Kovo?
Master Kovo. Did you point it out to him?
No, we were there for a specific collection, a directed collection.
You were there to get the shovel and the plastic bag and the towel.
That's all.
And you did a pheno test on the towel and it came out negative, right?
I don't know if we did it on that day, but at some point, the towel was tested in the field. I don't know if it was done on the 14th or the 28th. I'll have
Now-
to check my notes. The towel was tested on the 14th of June.
On July 6th, you took another trip to the Bronco at the request of Miss Clark.
Yes,
And you did this just before you testified at the preliminary hearing.
yes,
And that was after Detective Furman had testified at the preliminary hearing.
yes,
And you were informed by Ms. Clark that Detective Furman had testified to seeing 4 red stains on the exterior of the door sill.
She didn't name Detective Furman by name, but she did say detectives had seen them and she would like me to do a presumptive test on those areas.
And did she tell you on the morning of July 6th that one detective had testified to seeing it, these red stains, and two other detectives had testified at the preliminary hearing that they hadn't seen it?
No.
She didn't indicate anything to you about a conflict in testimony?
She just requested me to look specifically at that area and do a presumptive test on it.
Now, this trip that you made to the Bronco on July 6th, you first revealed this in testimony at a hearing in October of 1994.
Yes.
And that was when you were called by the defense to testify.
I don't recall who called me, but I did testify.
Do you recall on direct examination in October being asked questions by Dean Ullman?
Yes, I do.
You know who he is?
Yes.
And he asked you questions about the number of times you had taken trips and inspected the Bronco.
Yes.
And when he first asked you about this trip to the Bronco on July 6th, you told him, I went to the Bronco and looked to see if it was there, referring to the red stains. That's all I did.
On July 6th?
Yes.
Page and line, counsel.
Yes. Is the transcript of October 6th. And I'm referring to questions that begin at 2581. And maybe to make it easier, I'll start on line 1 of 2581, and I'll read.
Let Mr. Goldberg catch up.
This is the hearing on October 6th. If you want. Here's a copy.
Ron, I will ask that Mr. Scheck read from the official transcript because there's no vouching for the accuracy of what was.
Are you,
Hold on. Let me see counsel with the sidebar, please. All right, thank you. Counsel, have you had the opportunity to compare your transcripts? Here to. October
This
26th.
is October 6th. And for the sake of clarity, Your Honor, I'll begin actually at page 2580, line 23, which is the very beginning of the direct examination by Mr. Ullman. Question. All right, Mr. Fung, you participated then in 2 different searches of the Bronco automobile. Is that correct? Answer, yes. Question. 1 on June 14th at the print shed. Answer, yes. Question. And then a second one on June 28 at Vertel's. Answer, yes. Question. Did you visit the Bronco on any other occasion other than these 2 occasions when you were executing a search warrant? Answer, yes, I did. Question. When was that? Witness, let me refer to my notes. Brief pause. Answer. There was an additional time where I was asked to see if there was additional blood on the exterior of the door. And I did that the first time I testified on the same day that I testified in the preliminary hearing. I don't have that written down, though. Question. Okay, so you have no record of having made another visit to the Bronco automobile to examine it? Answer, no. Question. You did not prepare any report to that effect? Answer. I went to the Bronco, looked to see if it was there, and that was all I did. Were you asked those questions and did you give those answers?
To the best of my recollection, yes.
Now, later on in your examination at that hearing, you were asked some questions by Ms. Clark. Starting on page 2584, 2585, 2586.
Need one moment to try to get our 2 transcripts correspondence. We're reading up.
I have 2 copies here. Would it help you if I gave you my copy?
I think they need a copy to
Yeah,
run.
we don't have this condensed version, Your Honor. Oh, that's the same one that we have. So,
Well, they apparently don't have the whole thing,
okay,
they say.
let me see, can I see what the court has?
$25.84.
May I proceed?
Your Honor, I don't see anything consistent with this.
Just to pick up the theme for a second, Mr. Fung, what we just reviewed is that when you answered Mr. Ullman's questions, you told him, I went to the Bronco, looked to see if it was there, and that's all I did. You recall giving that answer.
Yes.
Then when Ms. Clark asked you questions, you were asked these questions and you gave these answers. Question. Now, on the date that you went back to the Bronco to look at it, which was the second day of your testimony, answer, I think so, yes. Question, it was during your testimony at the preliminary hearing during that time. Answer, yes. Question, how did you go get to the car? Were you just able to walk in through an open door? Answer, I went to Vertel's tow and I showed my badge or something to the attendant to let me into the garage area or the tow yard. And then I went into their print area and observed what was on the driver door. Question, so you had to show identification in order to be allowed in? Answer, sometimes I have to show identification, but if they recognize the police car, they'll open the door for me. Question, so if they know that you're a police officer, they let you in, otherwise you have to show identification? Answer, yes. Question. And when you made that examination, you looked at the bottom of the driver's door. Answer, yes, I did. Question. What did you see? Answer, there was a dark area with the appearance of possible blood. Question. Did you test it? Answer, yes, I did. Question. And it gave preliminary tests for the presence of blood. Oh, I'm sorry. Question. And answer, it gave preliminary tests for the presence of blood. Were you asked those questions, and did you give those answers to Ms. Clark?
From the best of my recollection, yes.
So, it's your testimony, or is it your testimony, that on July 6th, you went to Vertel's, the request of Ms. Clark, and you looked for blood stains on the exterior of the Bronco door?
The exterior of the Bronco door by the door sill.
Where
yes.
you indicated, the general area you indicated in the picture we showed you.
Yes.
And is it your testimony, sir, that you saw dark spots there?
It was dark in comparison to the rest of the vehicle.
Red stains?
I don't believe it was red at that time.
Were you alone when you made this visit?
I believe I was.
Did you bring any photographer with you?
No.
Did you conduct a presumptive phenolphthalein test?
Yes, I did.
And you got a positive result?
Yes.
And at that time, you did not write any report about having performed such a test?
That's correct.
You did not take any picture of those dark spots that you claim to have seen before you tested it?
That's correct.
Now, on July 6th, you came back to testify at the preliminary hearing.
Yes.
When you came back to testify, did you report to Ms. Clark that you had seen these dark spots on the exterior of the Bronco door?
I don't know if I relayed that to her at that time or if I had relayed that information to her before.
Well, you went out to look at this the morning of your testimony.
That's correct.
And are you saying that after looking at those dark spots, testing them for the presence of blood at Ms. Clark's request, that you did not immediately return and report to her what you had seen and what you had done?
I don't recall if I did or not.
Are you saying you don't recall, sir, because you think that that's going to be of some assistance to the prosecution's case here?
Sustained.
When you perform a phenolphthalein test, withdraw it. When you performed the phenolphthalein test on the exterior of the Bronco door on July 6th, you took a swab and you put some distilled water on it,
Yes.
and then you put that swab onto the dark spot you saw and removed some of it?
A portion of it. Yes.
Sure of it.
Yes.
Now, at some point, did you report to Ms. Clark what you had done on July 6th?
I did relay to her at some point that I had done what she requested of me, yes.
Did she take any notes when you relayed this information to her?
I don't believe she did. I'm not
Where
sure,
did
though.
this conversation take place?
It was in the DA's office someplace.
Did you relay this information to Ms. Clark before you testified on July 6th and July 7th at the preliminary hearing?
I don't recall when exactly I related to her.
Can you think of any possible reason that you would not tell Ms. Clark on July 6th or 7th what you'd seen on the bottom of that Bronco door, if you'd seen it?
Assume specs on evidence and sorry.
Overruled.
This was a minor thing in my mind. I didn't. In my mind, I didn't place a lot of significance on it. It was a request that she made of me, and I performed the phenolphthalein test, and at a later time, I said, I've done it, and that's all I thought about it.
A minor thing.
Is that a question?
You thought it was a minor thing.
I didn't think it was needed a report written at the time that I did it.
Well, you didn't fill out a report about doing this until October,
That's correct.
but it is required at the SID laboratory, at your crime laboratory, that if you are to perform a presumptive test in a case, you're supposed to make a record of it.
That's in that proposed manual, but I don't know if it's actual policy or not.
Well, isn't that your general practice, that when you perform a presumptive test on an item of evidence in a case, you make a report about it?
It's irrelevant.
Overruled.
In certain instances, yes.
You would make a report about it if it really happened, if you really went out there and saw those dark spots and did a presumptive test, right?
I'm going to sustain the court's own objection to that question. Rephrase the question.
Mr. Fung, would it not be your practice if you had in fact gone out, seen dark spots on the door sill of the Bronco on July 6th and done a presumptive test, would it have not been your practice to make a report about it?
Not necessarily, no.
Was it so minor an event that you not only didn't tell Ms. Clark about it, but you didn't feel it necessary to make out a report?
I told Ms. Clark about it at some point in time, I don't recall when, and eventually I did make a report.
And you're telling us, sir, that on July 5th, you thought that seeing a red stain on the exterior of that Bronco door was a minor thing not worth mentioning.
I want to rephrase the question. You got the date.
You thought it was a minor thing not worth mentioning to Ms. Clark.
I may not have had the opportunity to sit down and talk to her about it. I don't recall when I talked to her. I may have talked to her about it at that time. I don't recall when, though.
Well, you testified at that preliminary hearing on July 6th and 7th.
Yes, I did.
And that testimony was on national television.
Yes, it was.
And you were recounting the events of June 13th.
Overruled.
It's also irrelevant.
Overruled.
And I was recounting the events of June
Yes.
13th.
Part of your preliminary hearing testimony under questioning from Ms. Clark was to recount the events of June 13th and your role in collecting evidence.
Yes.
Are you telling us, sir, that you did not have a discussion with Ms. Clark about your testimony before you testified?
I did have a discussion with Ms. Clark before I testified.
And in that discussion, did you give her any report about seeing dark spots on the exterior door sill of that Bronco?
Based.
Oral.
During our that was the point in the conversation where she requested me to look specifically and do the test for phenolphthalein at the bottom of the door sill.
Oh, so you had a conversation with her on July 6th, and when the issue arose about these red stains, she then directed you to go to Vertel's and look at the door sill.
No, that's not what I said.
Well, please clarify.
There was a conference that we had prior to my pretrial conference or pretrial hearing testimony in which we discussed what I did, and at that time she made that request for me to do a presumptive test at the driver door sill of the Bronco.
And when she made that request, did she suggest to you bring a photographer so that you can document the existence of these red stains before you do a test?
No, she did not say that.
Did it occur to you that that might be a good idea?
Not at the time, no.
When you finished this test and your observations on July 6th, I ask you again, sir, did you come back and report to Ms. Clark before you testified on your findings?
I don't recall if I told her before I testified or not.
At the preliminary hearing, you were asked no questions, were you, about seeing any red stains at the bottom of that Bronco door?
No, that's irrelevant.
Overruled. Do you
I
recall?
don't recall.
And you did not testify, sir, about seeing red stains on the bottom of that Bronco door.
Irrelevant. He wasn't asked.
Overruled.
I don't recall.
Mr. Fung, isn't it true that you never saw any red stains on the bottom of that Bronco door on July 6th?
No, I did see a stain that gave a positive for the presence of blood at the bottom of the door sill there.
Isn't it true, Mr. Fung, that you never removed anything from the bottom of that Bronco door on July 6th for purposes of performing a presumptive test?
I did perform a presumptive test on a dark stain at the door sill of the driver door.
And you removed some of that stain, some of that evidence for purposes of your test?
Yes.
Because you've told us that the stain is the evidence.
Yes.
And you're sure of that?
Yes.
You're as sure of that as the fact that when you took that envelope on June 13th, you didn't take it with your bare hands?
It's argumentative, counsel.
Mr. Fung, isn't it true that you went out on July 6th to look at the Bronco simply to refresh your memory for court?
I went there specifically to look at the driver door sill and perform a presumptive test on it.
Mr. Fung, you are aware that a Detective Muldorfer from the LA Police Commission conducted an investigation with respect to break-ins of the Bronco at Vertel's.
Sustained.
Were you questioned by a Detective Muldorfer with respect to your visits to the Bronco?
Irrelevant.
Overruled.
No.
No. Were you questioned by anyone from the LA Police Commission with respect to visits to the Bronco?
No,
No recollection of that at all?
none.
You do not recollect telling Detective Muldorfer or anyone else about all the different times that you visited the Bronco at Vertel's?
I don't recall any personal interviews. There may have been a phone conversation, but I don't recall.
So you recall a phone conversation?
There may have been a phone conversation, but I don't recall any personal conversations.
Did you not, on August 8th, 1994, have an interview with Detective Muldorfer with respect to your visits to the Bronco?
I don't recall.
Was it a Detective Carson?
I don't recall any personal interviews.
Did
With
you
them.
tell anyone on August 8th that you visited the vehicle on July 6th to refresh your memory for court?
I don't recall saying that.
Did you tell anyone on August 8th that you did not remove any evidence from the vehicle on July 6th?
That's not consistent.
Call roll.
Taking that swab and swabbing the dark spot?
Call roll.
Taking a swab for presumptive tests and collecting are two different things.
After you took the swab and rubbed the dark spot on July 6th, was any red stain left?
I don't recall if any was left or not. I don't think I used up the whole stain.
Well, you didn't use up the whole stain. Did it ever occur to you to suggest somebody should go back and take a picture of what was left?
No,
Never made that suggestion to anyone.
no,
Ms. Clark never told you to go back and take a picture of it.
no.
Didn't you tell someone on August 8th, with respect to this investigation of the Bronco, that you did not remove any evidence on July 6th, and you did not notice any papers in the vehicle at that time either?
I didn't look for papers in the vehicle.
Are you sure, sir, that you did not tell someone from the LA Police Commission that you visited the vehicle on July 6th to refresh your memory for court, and you didn't remove any evidence from it?
I don't recall the exact conversation. I don't even recall talking to somebody from the LA Commission, Police Commission.
One moment. Mr. Fung, before we leave this topic, let me just show you some documents to see if they refresh your recollection.
Sustain.
Well, you've indicated that you don't recall speaking to anybody from the Los Angeles Police Commission with respect to your visits to the Bronco.
I don't remember any specific conversations, no.
All right? May I,
Couple more questions.
I'm sorry?
Couple more questions.
All right? Would it refresh your recollection, sir, to examine some documents as to whether or not you had any conversations with someone from the Los Angeles Police Commission with respect to your visits to the Bronco.
Oh,
It may but I don't know what the source of the documents are.
All right? May I approach, Your Honor?
you may.
Yes. Your Honor, I asked that...
Why don't you just show it to counsel?
Yes.
Approach again so the court can see. Take a look at this.
I'm aware of what these documents are, counsel. We had a whole proceeding on these documents.
May I approach the witness, Your Honor?
Please.
Please take your time, showing you a series of documents, and in particular, and to address your attention to paragraphs, the page that's marked here, 1187, and there's another short one here. I've tabbed them with yellow Post-its. Please take your time, look at all the documents for as long as you want. Sir, having examined these documents, is your recollection refreshed about having a conversation with anyone on August 8th about your visit to the Bronco on July 6th?
Even from reviewing those notes, or that report, my memory is not refreshed.
So as far as the way you would like to leave it, sir, is that you never,
Phrase the question.
is it your testimony, sir, that to the best of your recollection, you were never interviewed by anyone from the Los Angeles Police Commission with respect to your visit to the Bronco on July 6th?
Sustain.
Were you interviewed by anyone from the Los Angeles Police Commission on August 8th, sometime in August, about your visit to the Bronco on July 6th?
I don't recall any personal interview. It may have been telephonic.
Well, do you recall a telephonic interview?
No, I don't.
And is your testimony, sir, with respect to red stains in the Bronco that you're given to this jury in any way motivated by a desire to cover for Detective Furman?
No.
Now, I'd like to turn to a new topic, Your Honor. I won't be able to finish it before the break, but might as well start it. I can't.
Try.
I'll do my best, but we're going till 12? Mr. Fung, you've told us that on the afternoon of June 13th at Rockingham, you received Mr. Simpson's blood vial from Detective Van Adder.
Yes.
You did not receive this blood vial for the first time on the morning of June 14th.
That's correct.
Now, did you discuss in your preparations for this case, the district attorneys, this issue as to when you received the blood vial?
Phrase the question.
Did you discuss with the district attorneys the circumstances of how you received the blood vial in this case?
Yes.
And was that an issue that you discussed at some length?
About 15 minutes.
Did you discuss the issue about how you received the blood vial with Michelle Kessler,
I don't believe so, no.
with Greg Matheson,
No.
with Detective Van Adder,
By issue, do you mean why it was done that way, or?
did you discuss with Detective Van Adder before you came here to testify, preparation for your testimony, the circumstances surrounding your receipt of the blood vial from him?
No.
Oral.
Did you have any discussions with Detective Van Adder concerning how Mr. Simpson's blood vial was turned over for purposes of booking?
Could you repeat that question?
Could you tell us, you said did you have some discussions with Detective Van Adder about Mr. Simpson's blood vial?
Yes.
When?
The day I received them from him.
Since then, any discussions?
Not to my recollection, no.
Any discussions with respect to the decision to bring the blood vial from downtown to you at Rockingham?
No.
Did you discuss the circumstances of receiving Mr. Simpson's blood vial with Detective Lang prior to coming in here and testifying?
I don't recall any discussion about that, no.
So other than the prosecutors, in preparation for your testimony, you have not had a withdrawn. Did you discuss the circumstances of the receipt of Mr. Simpson's blood vial with Andrea Mazzola?
I only stated to her that we did receive, or I did receive the blood vial from Detective Van Adder.
When did you have that discussion?
That was the morning of June 14th.
Now, who was present, according to you, at Rockingham when you received the blood vial from Detective Van Adder?
We were in the foyer, and I was there, of course. Detective Van Adder was there. And I know there were other detectives around, but I don't recall who they were exactly at that point in time.
So you're saying that was in the foyer of Mr. Simpson's home?
That's when I received the envelope containing the vial of blood.
That was inside.
Yes.
Was the door closed?
I don't recall.
Can you describe for us in as much detail as you can recollect exactly how this transfer occurred?
Detective Van Adder said to me, or something to the effect of, I have Mr. Simpson's blood, and I want you to book it.
Now you made a gesture with your hand.
Yes.
And are you indicating, sir, that he then gave you something?
Yes, that he gave me the envelope containing the vial.
Right? And where was he? Was he holding it in his hand?
Yes.
When did you first see Detective Van Adder before he gave you this envelope?
I don't recall exactly when he came, but I do recall that particular event.
And did he take it out of something, or did he just have it in his hand?
I don't recall.
Did he pull it out of a black duffel bag and give it to you?
I don't recall him having a black duffel bag.
You didn't see him carrying a black duffel bag.
No.
Did he take it from a clipboard and give it to you?
I don't recall him having a clipboard either.
So, to the best of your recollection, Detective Van Adder handed you a gray envelope and he just had it in his hand.
To the best of my recollection, yes.
And then, after you received that gray envelope, what did you do with it?
I wrote on the envelope that I received it from him, and I put the time, date, and my initials.
And what did you do with the envelope at that point?
I looked inside to make sure that there was a vial in it and that it was in a condition that was unopened, and I put it in the crime scene truck.
Well, we're still in the foyer when you got it, correct?
Yes.
Did you open it, the envelope in the foyer?
Yes.
And that's when you looked at it?
At the vial.
Yes.
Yes.
And when you, did you then, what did you have with you at that time, if anything?
I had a pen.
And after you received the envelope from Detective Van Adder in the foyer, did you then walk out the door to the crime scene truck?
I don't know if I did that immediately or if I had other things that I had to do prior to that.
Did you put this envelope in a brown paper bag?
I don't recall if I did or not.
Did you put it inside your black kit?
No, I don't think I did that.
Did you, at some point, walk out of the foyer to the crime scene truck holding the gray envelope?
I don't believe so.
Well, what did you do with it? How did you get it to the crime scene truck?
It may have been in a paper bag, but I don't recall if I actually did put it in there, or it may have been put in a posse box.
It's possible you just walked out the door with the envelope in your hand?
It's possible, but I don't think that's likely.
All right, Mr. Scheck, we're going to take our break at this time. All right, ladies and gentlemen, please remember all of my admonitions to you. Do not discuss this case amongst yourselves. Do not form any opinions about the case. Do not allow anybody to communicate with you. Do not conduct any deliberations till the matter has been submitted to you. We'll stand in recess until 1:30. Mr. Fung, you're ordered to return 1:30. All right, we'll stand in recess, and greetings to Judge Scott. Thank you. Mr. Scheck, you had a discovery issue you wanted to raise?
Yes, Your Honor. And I would request that the witness be asked to leave the room for a moment.
All right, Mr. Fung, would you wait outside for a few moments, please? Thank you, sir. Mr. Scheck.
Thank you, Your Honor. Your Honor, as I'm sure the court is well aware, one issue of great interest in this case are the activities in the at SID on the morning of June 14th. And discovery request was made for computer records that reflected who went in and out of the doors in various rooms at SID. And the prosecution, in particular the evidence processing room on the morning of June 14th. The prosecution turned over to us a series of pages starting in the murder book at DA 04329 to DA 04334. Actually, these pages are backwards in terms of chronological order. That is to say that 04329 purports to be records of June 16th, and then they go from the 16th to the 15th.
Probably that's how it came out of the photocopy machine.
Whatever it did, the 14th to the 13th. The problem is, however, with respect to on page 04333, we received records about June 14th. And those were the only records we received. The records of June 13th were then contained on 04334. So these are consecutively numbered pages. We noticed this morning in preparation for court that the first entry that we had on June 14th for someone entering the evidence processing room was 9:27 a.m. Actually, what I'd request is that perhaps these pages be marked as exhibits at this point in time.
All right. Defense next in order, which would be 1099.
My colleague, Mr. Neufeld, who is a bit under the weather, has been monitoring these proceedings from his hotel room and made a telephone call to Greg Matheson at SID during the course of the testimony of Mr. Fung and made an inquiry as to whether or not there was an additional page reflecting who went in and out of the evidence processing room on June 14th. And again, Mr. Neufeld was reviewing those records that I've just mentioned to the court. Mr. Neufeld informs me that Mr. Matheson confirmed that we were indeed missing a page with respect to earlier times, but indicated that he did give that page to the district attorney's office. Mr. Neufeld has read to me over the phone information that he received from Mr. Matheson with respect to the times.
On the 13th or the 14th?
I'm sorry, on the 14th.
Right.
The times of the 14th, and the missing page. And those times contradict, I believe, the testimony of Mr. Fung. We have Mr. Fung in the evidence processing room at 7:45. Then we have him back entering the evidence processing room at 7:50. And we have other individuals in and out of that room starting at 6:03 a.m. My concern, Your Honor, is that we didn't get this page and the consecutive numbering of the documents. Obviously, would we request an explanation for the prosecutors if this court were to make a finding that this document was deliberately withheld? What we would ask is that we get an actual copy of this document to the court, that we confront Mr. Fung, but most importantly, that the jury be instructed that the document was intentionally withheld, if that in fact turns out to be the case. All that I can do is relay the information that I have. It's a matter of concern to me, but of course I await the explanations from.
All right, Mr. Goldberg?
Your Honor, I think counsel has unintentionally misstated the record. I don't believe the defense ever made a request for access in or out of the room. The way it came about is I asked for those records for the purposes of trying to determine certain time sequences and voluntarily produced them to the defense without any request whatsoever. So I'd ask Mr. Scheck, if he can, to find a citation in the transcript where that was requested, because I'm simply unaware of it.
Oh, I don't dispute that the events may have occurred that
Mr.
way.
Scheck, before we launch into that issue, the issue that I'm concerned about now, since I have a jury waiting, is where is this document? Can we make it available for Mr. Scheck to examine and for both sides to examine? And let's continue with the cross-examination and redirect of Mr. Fung. And we can take up to the issue of where it was and why it didn't show up in your package at a more appropriate time. But I would like to get finished with Mr. Fung today.
You know, I just would like to say for the record that what I have in my notebook is identical to what counsel just described. And I personally Xeroxed it and have delivered it to them, which probably accounts for why it's in reverse chronological order. Xeroxing is not one of my strong points. But I would just like to say for the record that I just think it's unfortunate that every single legal issue that is raised is always couched in terms of some allegation of misconduct. And I just think it's a very sad way to litigate.
Counsel, I'm not immediately leaping to that conclusion, so don't get your feathers ruffled up at this point. My concern is let's proceed with the cross-examination. Can we get this document? Can we get somebody to fax it to the court?
I want to be clear. I'm just stating the facts, and I would certainly concede that I do recall that we did have that conversation, more or less as Mr. Goldberg says it, in terms of we were interested in these documents, and he was too.
I can
and he
gauge from your
delivered
tone,
these.
wait. I'm not interested in this issue.
That's fine with me, Your Honor.
Today, I don't care about it. Later this week, I'll care about it. Can we get Mr. Matheson to fax us the sheet?
You don't have it either, Mr. Goldberg.
No, I can see what I have.
All right?
No, I believe it.
Who's got the phone number for Mr. Matheson?
I'm ready to proceed at the present time.
Do you want to proceed without it?
Well, I can proceed at this point without it, and I thought the court wanted to, get the documents and resolve the issue, and you wanted me to proceed.
No, if we agree that what comes from Mr. Matheson is a copy of the original document, if you feel you need it to cross-examine Mr. Fung further, we'll get it for you, and hopefully we can get it faxed to us in a matter of minutes.
Oh, okay.
Both sides will get a photocopy and we can proceed.
Ms. Martinez is calling Mr. Matheson and
All right,
see if we can have it back.
great. Okay, let's proceed. All right, Deputy McNair, let's have the jurors, please, and can we have Mr. Fung, please? Mr. Dennis Fung is again on the witness stand undergoing cross-examination by Mr. Scheck. Good afternoon again, Mr. Fung.
Good afternoon.
You are reminded, sir, that you are still under oath, and Mr. Scheck, you may conclude your cross-examination.
Good afternoon, ladies and gentlemen of the jury. Good afternoon, Mr. Fung.
Good afternoon.
Mr. Fung, when we left off, we were discussing what you told us about the transfer of the blood vial to you in the foyer of Mr. Simpson's home on the afternoon of June 13th.
Yes.
Now, do you recall what you were doing just prior to the transfer of this blood vial?
No, I do not.
Do you recall that an item number 15 was retrieved from a trash basket in the foyer?
Yes.
And an item number 16 was retrieved from a bench outside the front door of Mr. Simpson's home?
I've checked the evidence.
Not mentioning what it is, just that there were items in those locations.
All right, I'll allow it to stay.
Now, do you recall that?
Yes.
All right. Now, did you receive the blood vial before items 15 and 16 were collected?
No, I received it afterwards.
And you just refreshed your recollection by looking at your notes?
Yes, I did.
And the notes reflect that those items were picked up at 5 o'clock.
Yes.
And since you're telling us that you received this blood vial at 5:20, you have concluded that this was after those two items were collected.
Yes.
Now, but do you have, as you sit here today, an independent recollection of the order in which you received the items other than looking at your notes?
No.
Now, you mentioned to us that you thought that you put the envelope containing the blood vial in a paper bag or what you called a posse box.
It's testimony.
Sustained.
Well, what is a posse box?
Posse box is a note pad that's metallic. It has a cover on it that you can store. It's a box that's shaped like a notepad, except it can carry things.
Did you have one of those with you that day?
Don't recall if we did or not.
Were you carrying one, to the best of your recollection, that day when you left Mr. Simpson's front door to go back to your crime scene truck on the afternoon of June 13th?
I don't recall if I was or was not carrying a posse box.
All right. To the best of your recollection, how did you carry this gray envelope containing Mr. Simpson's blood vial when you withdrawn? I take it at some point in time you left the foyer area and returned to your crime scene truck.
Yes,
And you were carrying that gray envelope.
either by itself in a posse box or in a paper bag.
So it would be one of those three ways of carrying it, either out by itself in your hand, in a paper bag, or in a posse box.
Yes.
And when you, okay. Mr. Fung, was it your idea to have Detective Van Adder take Mr. Simpson's blood vial from the Parker Center to Rockingham to deliver it to you?
No, it was not.
Did Detective Van Adder call you up and ask you if you wanted to have Mr. Simpson's blood vial booked at SID and a DR number bought before he brought it to the scene?
No.
Would it not be normal practice upon receipt of a blood vial for a detective to buy a DR number and book it either at Parker Center or at SID so the blood vial could be refrigerated?
False for speculation.
Sustained without further foundation.
Do you have knowledge of the usual practices by which blood vial samples are booked in the course of cases?
It's vague as to what criminal was.
Sustained. First question.
Do you have knowledge of how blood vial samples are supposed to be booked or are withdrawn? Do you have knowledge of how blood vial samples are supposed to be booked by police officers?
I have a limited knowledge of that.
And that limited knowledge comes from the LAPD manual?
In part, yes.
And the practice is that upon receipt of a blood sample taken from a suspect, that the detective is to book it either at the property room or at the SID center.
There's still an inadequate foundation.
Overruled. You can answer the question.
The manual is used as a guide, and that's the guideline for officers, yes.
Has anybody discussed with you the phrase, the manual is to be regarded as a guide?
Overruled.
Yes.
Did Detective Lang have any conversations with you about the LAPD manual being considered a guide, but not a guideline, or just a guide to govern the conduct of officers?
I have heard him say that, and I've heard many other people say that also.
When did you hear Detective Lang talk about the rules in the LAPD manual being guides?
I don't recall when. It was sometime after this investigation started, though.
About how long into it?
I don't recall when. I do recall him as being one of the people who said that, though.
And do you recall how that subject came up, that the rules in the LAPD manuals were to be regarded as guidelines?
I don't recall the exact, what led up to that conversation.
Was it a discussion in which you were pointing out to Detective Lang that he hadn't followed the rules in the LAPD manual?
No.
Well, with respect to your knowledge of the LAPD manual, is it not the practice that a blood vial taken from a suspect is to be booked as soon as possible?
There's no foundation in this practice.
Could you please repeat the question?
From your knowledge of the LAPD manual, is it not the rule that a blood vial taken from a suspect
Blood
is-
sample.
blood sample taken from a suspect is to be booked as soon as possible?
I don't know if that's exactly what it states.
Well, in terms of your understanding, does that comport with your understanding? Is that consistent with your understanding of what the rules require?
That's vague and
Overruled.
also hearsay.
Overruled.
That's somewhat consistent with the exact wording or of what the manual wants.
And in terms of your understanding of the manual, the practice in this case should have been for Detective Van Adder to buy a DR number down at Parker Center and book Mr. Simpson's blood vial either at the Parker Center or at SID.
Also speculation.
Sustained.
When we talk about booking a blood vial from a suspect, do you mean that that vial in the analyzed evidence envelope is handed to somebody at the evidence control unit at SID?
According to the manual, I believe the definition of booking is the registering of property into departmental records, or the process of entering into departmental records, evidence or persons.
And your understanding of entering it in departmental records would mean in the case of a blood vial, such as the one at issue in this case, that it would be turned over to someone at the evidence control unit at SID. That would be one way of doing it.
Well, if we're going exactly to the letter of that definition, as soon as it's marked on some type of departmental record, that would begin the booking process.
When we used the term booking before, all right, withdrawn. Would not the booking of the blood vial be accomplished by taking it to the evidence control unit, handing it to the clerk, buying a DR number, and having the blood vial refrigerated?
In that order?
Yeah.
Couldn't do it in that order.
Buy a DR number and then give it to someone at the evidence control unit so it could be refrigerated.
That would be the final stage of booking.
Could Detective Van Adder, under the rules as you knew them, have done that on June 13th? Gone right over to SID after buying a DR number and give the clerk at the evidence control unit the blood vial?
Also speculation.
Sustained.
In terms of your understanding of the rules, would that have been consistent with the rules?
It's irrelevant.
Oh, well, you can answer that question.
That would have been one way to have done that.
And isn't that the way, in your experience, it's ordinarily done by detectives?
No foundation for that.
Sustain.
You have been working as a criminalist for 8 years.
10 years.
10 years, my apologies. And you have been doing crime scenes for how long?
Almost 10 years.
And in your experience, is it not the ordinary practice that after detectives get a blood sample from a suspect, that they take it to the evidence control unit and book it there?
In my experience, I have never had a detective obtain a blood sample that quickly.
So it would be your testimony that in your experience, you've never known a detective not to obtain a detective withdrawn. In your experience, what you know is that detectives ordinarily get blood vials from suspects and book it.
Sustain.
In your experience, have you ever before been in a situation where a detective obtained a blood vial from a suspect?
Sample. Sample. You keep saying blood vial.
Okay,
Sample.
thank you, Your Honor. Obtained a blood sample from a suspect, and instead of booking it downtown where it was taken, at SID or at Parker Center, drive it all the way back to a crime scene. Has that ever happened in your experience?
It's irrelevant.
Oh, well.
No foundation.
I can't remember one instance where that's happened.
Thank you.
Have we about exhausted this line of inquiry?
To your knowledge, there is a place in Parker Center where this blood vial could have been booked and refrigerated if a DR number had been obtained. You know that.
Blood samples can be booked down at Parker Center.
So, you examined, you've told us, this blood vial.
I looked at it, yes.
And in looking at it, you determined that it had been drawn, at least by the markings on it, at 2:30 in the afternoon.
I looked at the vial to see if it was intact, and I did look at the envelope, but I don't remember all the writing on the envelope.
So you can't tell us whether or not this was actually drawn at 2:30 in the afternoon.
I don't remember. I'd have to refer to the envelope itself.
But as far as you knew, before Detective Van Adder brought it to you, he'd been carrying it around for some hours.
I didn't stop to think how long he'd been carrying it.
Did you inquire of him how long he had been carrying around this blood sample?
No, I did not.
Did you consider that part of your responsibility in terms of maintaining chain of custody?
No, because that would be his part of the chain of custody.
You don't consider it your responsibility as the criminalist that's gathering and booking evidence to determine where objects have been before you get them?
It's my responsibility to record when or where I get things from and when I dispose of them, or not dispose, but remand them into the custody of somebody else.
Well, you were concerned enough on June 13th that you actually opened the envelope up and looked at the blood vial when Detective Van Adder gave it to you.
Yes.
Before withdrawing, Detective Van Adder have any way of contacting you from downtown on the afternoon of June 13th?
Yes.
Beeper? You wear a beeper?
Yes, I do.
Carry a cell phone?
Yes, I do.
You could have been beeped then and called on a cell phone and asked by Detective Van Adder if you wanted to have this blood vial taken from Parker Center all the way across town to Rockingham.
Overruled.
I don't give anybody my cellular phone number. He could have called DHD or the office and had me paged, though.
Could you explain that? He could have called where?
Counsel, you said he's got a pager.
Oh, I'm sorry. You had a pager,
And
so
he was available by
you
pager.
were available, could have been called by a pager.
Yes.
During the course of the day, had you been contacted by Detective Lang or Detective Van Adder through that pager?
No.
Were you contacted by Mr. Matheson?
Yes.
You recall being contacted by Mr. Matheson around 12 in the afternoon while you were at Bundy.
I don't remember being called by Mr. Matheson at that time.
Do you recall sometime around midday that Mr. Matheson called you while you were out at Bundy and asked if you needed any help at the crime scene?
I don't recall that.
Didn't happen?
I just don't recall if that happened.
Now, so it's your testimony, sir, that you were never contacted by Detective Van Adder before he brought the blood vial crosstown to you.
Yes.
Now, on the morning of the 14th, you received some tennis shoes from Detective Lang.
Yes.
Now, you told us just before we broke that you recalled this occurring around, what, 7:30, 7:40?
Between 7:30 and 8 o'clock, around that time, maybe a little later.
And this occurred, you say, in the serology lab?
To the best of my recollection.
Could it have been in the evidence processing room?
I don't remember I don't remember Detective Lang being in the evidence processing room.
Well, you told us that when you saw Detective Lang have sneakers with him, that he was in the serology lab.
Yes.
And the swatches that you'd retrieved from Bundy were in the evidence processing room.
Yes.
They were in a cabinet.
Yes.
It was unlocked.
The cabinet? Yes.
Now, there's a computer printout that shows who enters and leaves the evidence processing room during a particular day.
It records when somebody uses their keyless badge to open the door.
Right. And the way this keyless badge works is that there's a little rubber kind of thing that you put your badge across. Is that right?
There's a sensor in the wall, and it somehow detects the card, and if your card has the proper access code, then it'll let you in.
Now, if you were walking through the door of the evidence processing room, and let's say I was standing next to you, and you used that sensor, your badge, right?
Yes,
The door would open,
yes,
you would walk in, and I would walk in.
yes,
But there would be no record that I entered.
that's correct.
The only record would be that you entered.
Yes,
And you indicated before that you reviewed some records with Mr. Goldberg of what they call card transaction reports indicating who went in and out of the evidence processing room on the morning of June 14th.
yes,
Now, isn't it true, sir, that you entered the evidence processing room at 7:45 on the morning of June 14th?
It's unclear whether he's asking for his personal recollection of the document.
Oh,
I would have to refer to the document.
Your Honor, I'd ask that this document be marked defendants next in order.
1100. What happened to 99? We used 1099? Got it. 1100. 1100.
1100. May I approach?
You may.
Mr. Fung, I show you what's been marked as defendants 1100 and ask you to examine it.
I'm going to object to this as with an approach.
All right, with the court report, please.
You may continue to...
Hold on. Hold on. All right, thank you, counsel. Mr. Scheck.
Your Honor, is it feasible if I approach you to see?
Certainly.
Now, what do you recognize that document to be, sir?
Except for Mr. Goldberg, you need to not stand between the witness and the jurors.
I've never actually seen one of these documents before, but it looks like one of the, well, I have seen the document before. I take that back. It's a card access document.
And does this appear to be a card access document for the morning of June 14th?
Yes,
And does it indicate, sir, that you were in the evidence processing room at 7:45?
it indicates I used my card for entry. Yes,
And does it indicate that you then used your card for entry again at 7:50?
yes,
Does it indicate that Mr. Matheson was in the evidence processing room at 7:44?
yes, it does.
Now, having looked at this document, is your recollection refreshed that when you entered the evidence processing room at around 7:45, the morning of June 14th, that's where you saw Detective Lang with the sneakers?
I don't recall the sneakers and him being there. That's just my recollection.
But as I understand your previous testimony, you recall seeing Detective Lang between 7:30 and 8 o'clock, sometime around then.
Yes,
That's when the meeting occurred with you, Detective Lang, and Mr. Matheson, to the best of your recollection.
to the best of my recollection.
And looking at these records, Can you now tell us, sir, if that meeting could have happened in the evidence processing room?
It calls for speculation because this record doesn't have anything to do with it.
Overruled.
A portion of the meeting may have occurred there. However, I specifically remember the sneakers being in the serology lab, along with Mr. Matheson and Criminalist Yamauchi and myself.
Is there any reason, Mr. Fung, that you don't want to remember Detective Lang being in the evidence processing room with the sneakers when you walked in there?
Sustained.
When you saw Detective Lang on the morning of June 14th with the sneakers, you realized that he had taken them home.
I don't know if he had taken them home or not.
Did he tell you that he had recovered these sneakers from Mr. Simpson's residence on the afternoon of June 13th?
This calls for hearsay.
Sustained.
Mr. Fung, you are responsible for itemizing in your reports when and where those sneakers were recovered.
That's not exactly true, no.
No?
In my report, I am responsible for stating how they came into my custody.
And are you required to determine from the person who's giving it to you where and when the items of evidence were recovered?
It's my practice when I receive evidence from other or from police officers or detectives that I specify that they keep good notes as to where and when they got or recovered the evidence, and I am only going to put down in my proper report that I received it or that I received the evidence from them.
Did Detective Lang show you any notes about where and when he had recovered the sneakers?
No.
Did he indicate to you in any way that he had recovered these sneakers on the afternoon of June 13th?
And it calls for hearsay.
Sustained.
Let me ask you to assume for a second, Mr. Fung, that Detective Lang had recovered the sneakers on the afternoon of June 13th, brought them home, and then brought them back to SID and turned them over to you. Are you with me on this hypothetical so far?
Yes.
Would that not be a violation of LAPD Rule 510.10?
What is,
Sustained.
Do you know of a rule in the Los Angeles Police Department manual that indicates that evidence and non-evidence shall not be stored in the personal possession of any employee except for certain forgery-related evidence?
No comment.
Sustained.
May I approach the witness, Your Honor? Show him a document.
Certainly.
Mr. Fung, show you a document. Do you recognize it?
it appears to be a page out of the Los Angeles Police Department manual.
All right, and I'm going to direct your attention.
Check this. It's not an expert in it.
Overruled.
Are you familiar with
Let me see counsel at the sidebar. Without the report. proceed with increased alacrity.
Yes.
Mr. Fung, you recognize this document as being the Los Angeles Police Department Manual Rules concerning booking, custody, and disposition of property. What page from those rules?
It has the same format as the LAPD manual, yes.
And the LAPD manual rules on the booking, custody, and disposition of property are rules you are familiar with because that's part of your job as a criminalist.
I haven't read this per se, but I do follow the custom that I have been taught in the laboratory.
And as one of the, direct your attention to a paragraph here and ask you to read it to yourself.
Okay?
All right. Does that refresh your recollection that there, we'll call it a rule or a guideline, whichever you like, that evidence shall not be stored in the personal possession of any employee except for forgery-related material?
No authentication, hearsay.
Sustained.
Have you ever been told that evidence or non-evidence is not to be stored in the personal possession of a police officer?
Also hearsay.
Sustained.
Were you ever given instruction by anyone at SID that detectives are not supposed to store items of evidence in their personal possession?
Also hearsay.
Sustained. Mr. Scheck, why don't you phrase the question in the same manner that the witness has answered the question. His understanding is from custom that he's been taught in the laboratory. Ask him if it comports with that.
Thank you, Your Honor.
That would be an appropriate question.
In terms of the custom that you've been taught in the laboratory, has it been brought to your attention that evidence or non-evidence shall not be stored in the personal possession of any employee?
That subject has never been addressed to me.
So as far as you knew from the custom and practice in the laboratory, it would be perfectly all right for a detective to take evidence, bring it home, and then deliver it to you the next day.
No foundation.
Sustained.
When Detective Lang gave you the sneakers, did you suspect that there might have been anything wrong in the way that he was delivering them to you for purposes of booking?
No,
Did you mention to Detective Lang that you had some questions about how he came to be in possession of those sneakers that morning?
no,
You mentioned it to Mr. Matheson?
Overruled.
I didn't mention it to him, no.
Do you believe, Mr. Fung, in accordance with the custom and practice of your laboratory, that detectives have 24 hours to book blood?
No foundation, Your Honor.
Overruled.
I have read that in the manual.
In the manual?
You showed it to me this morning, didn't you? Something like that? No?
What manual?
The LAPD manual.
You think in the LAPD manual there's a provision that says detectives have 24 hours to book blood?
I may be mistaken. There was something to that effect of booking as soon as possible or 24 hours or something like that.
Well, is booking as soon as possible the same as 24 hours as far as you're concerned?
Sustained.
Did Detective Lang ever tell you that detectives have 24 hours to book blood?
Overruled.
No,
Detective Van Adder?
no.
If you received blood on the morning of June 14th at SID for the first time, in your judgment, would that have been improper?
No foundation.
Sustained.
As far as you understood the guidelines of the Los Angeles Police Department, would it have been improper for either Detective Lang or Van Adder to have gotten the blood from Mr. Simpson on June 13th, kept it in their possession, and then delivered it to you in the morning on June 14th?
Also speculation.
Sustain.
Your Honor, I'm trying to.
I understand what you're trying to do, but the foundation is not there.
All right. Let me ask you a hypothetical question. Let us assume that you received the blood that had been drawn from Mr. Simpson on June 13th on the morning of June 14th. You with me?
Yes.
If that had occurred, in your judgment, would that have been improper on the part of the detectives?
Sustain. Certainly. Problem here's foundation, counsel.
In terms of the custom and practice of your laboratory and its workings with detectives, would it have been improper if either of these detectives had kept the blood drawn from Mr. Simpson on June 13th overnight in their personal possession and then delivered it to you the next morning on June 14th?
Overruled.
That would depend on how the blood was stored in their, while it was in their custody.
You mean if they put it in their refrigerator at home, then in terms of your understanding and custom of practice, that would have been okay?
Overruled.
According to how I understand it, yes. I wouldn't recommend it.
Well,
Putting
why
it in their
would you
own-
recommend it?
Putting blood in your own refrigerator, just wouldn't recommend it.
Well, isn't one reason that you wouldn't recommend it, Mr. Fung, is that in terms of chain of custody, it would be highly improper for a detective to keep a blood vial overnight?
Sustained.
Mr. Fung, are you fearful of these detectives, Van Adder and Lang?
I'm not fearful of them, no.
Are you aware, Michelle Kessler is the head of the laboratory.
Yes, she is.
Are you aware that her husband works as a detective in robbery homicide with detectives Lang and Van Adder?
Overruled.
Yes, I am.
Are you fearful, sir, that in a dispute between yourself and either Detective Lang or Van Adder, that you could not count on the support of Michelle Kessler?
No.
Did you receive Mr. Simpson's blood vial on June 14th after you received the sneakers from Detective Lang?
I received the blood vial from Mr. Simpson, of Mr. Simpson, on June 13th at the Rockingham address.
So your testimony is you did not receive the sneakers first on the morning of June 14th and then the blood vial.
That's correct.
Do you remember being asked on direct examination which item you received first, the sneakers or the blood vial?
I don't specifically recall that question, no.
Do you remember making a slip on direct examination when you answered that question?
No, I don't.
Your Honor, I'd like to show a piece of video. It's,
I'd like to see it first.
yes,
Does it have audio?
yes, it does.
All right, let's ask the jurors to step back in the jury room, please.
I think it'd be done, all right, sorry.
All right, let the record reflect the jurors have withdrawn from the courtroom.
Ronna, how many times does the court have to admonish counsel to show us these things ahead of time? You know, and the grandstanding nature of these ploys has been made very apparent. This is the third time in front of this jury he's sprung tape on us, you know, without telling us ahead of time. The court has repeatedly admonished counsel to show us ahead of time and let us know.
Your Honor,
And repeatedly he's violated it, and once again, in front of the jury.
Well, the problem we have, though, is this is impeachment material. Let me see the tape.
well, this tape is his testimony.
It's impeachment
I understand.
material.
Yes, no, I'll
Do you
show
want to
the-
argue about this with me
No,
now?
no. I'll show the tape.
Show me the tape.
Yes.
Piece of paperwork. If the blood had remained item number 18, I would have had to create 3 additional property report face sheets.
Now, with the pair of sneakers on the previous document that we saw was labeled item 17, is that correct?
Yes,
Which did you receive, and the blood 18?
yes.
Which did you receive first, the blood or the pair of sneakers?
I received the blood vial first.
All right. And
That's
uh,
ridiculous. And I'm sorry, but the fact that this is impeachment.
Ms. Clark, are you handling this witness?
No, Your Honor, I'm just helping with Spirit over. But I'm not addressing an issue with the witness. I'm addressing an issue with counsel's.
Well, then we'll take that up
behavior in
later.
front of the court.
Counsel, we'll take that up later. Mr. Goldberg, any comment?
I don't feel this is proper impeachment because it's not inconsistent. And also, reasons we don't want to object to it.
And that's even counsel's conduct, and that's what I'm talking about.
Ms. Clark, didn't I just say we'll address this later? That means end of argument. I don't want to hear anymore. I'm tired of this. All right, 4 o'clock. We'll take it up.
Is there going to be any more videotape?
Yes.
Would be inquired?
Yes, I have some more videotape that just came, and if she wants to see it,
So let's
up
see it
to the
now.
court. Can the witness leave the room?
Yes.
Tape I'm going to show the witness, Your Honor, is a videotape of he and Miss Mazzola, but I believe depicts them leaving the Rockingham location on the afternoon of June 13th. There's an audio portion to this that I'd like to have played as well. What I hear on that tape is Mr. Fung saying to the witness, let's go back for one last check. Then we have another tape.
Where'd you get it?
Let me hear that again. And Ms. Fitzpatrick, can you crank it up?
Represent to you that this is another version of the tape, but we're fast forwarding to another section. When Mr. Shapiro was cross-examining Detective Van Adder, I was back in my hotel room and I happened to see this tape. Okay. We propose to play the portion of the tape that...
Take your phone, we're gonna make them take it to find the tape.
Not the
How do
audio.
you know that?
This is another shot, Mr. Fung and Miss Mazzola leaving on the afternoon of June 13th. Okay. We propose to show them those 2 seconds.
Mr. Goldberg?
I just know the relevance this council would have to think about for approval. But furthermore, there's no showing here as to why this wasn't provided in discovery. We have another discovery violation. Mr. Scheck made some kind of a strange comment about having viewed it or seen it in his hotel room at some point. I don't know how that gets around the discovery obligations to defense.
It's impeachment. I wasn't going to ask these questions. I wasn't going to show them this tape, Your Honor, till I heard what Mr. Fung had to say about how he carried this blood vial out there until he was nailed down. Now I'm going to show him the tapes.
All right, refresh my recollection. What specifically did he say? He said it was handed to him in a gray envelope and that he didn't recollect specifically how it was he carried it out.
He's had 3 possible ways that he could have carried it out. In a paper bag, in his posse box, or in his hand.
Okay. I saw him carrying a catalog case and a handful of paper bags.
Your Honor, before I'd like to make the rest of this offer of proof ex parte to you. I don't want to tell them. I think I'm entitled to that.
Well, counsel, you've just shown us, you've shown me a piece of videotape. You have to tell me why it's relevant.
Well, why it's relevant is that I believe that if I show these pieces of videotape to Mr. Fung and take him through, refreshing his recollection, looking at that, and take him through the events, that in combination with the testimony of Ms. Mazzola that the court has previously heard that's on the record, I think we can establish that what he's told us about carrying out that blood vial and how he carried it is not true.
And how do we do that from those 2 pieces of videotape?
Your Honor, I would again request that you permit me to tell you ex parte, make a record of it, and I will connect this up for you and show the plain relevance of it. I do not want to disclose that in front of these prosecutors who are going to talk to this witness or subsequent witnesses.
The witness will obviously, once you do it now, the cat will be out of the bag, so to speak. Mr. Fung is outside of the courtroom and he's not
No,
hearing this information.
there's more to it. There are other witnesses, and there are other events, and there's other reasons why these tapes are clearly impeaching, and I don't want to say it in front of them. I think I'm entitled to make this offer to you ex parte.
What's your authority for that?
Well, I think it's impeachment material. And I don't think I should be required under the discovery rules to reveal the impeachment material before I'm impeaching the witness. There are...
No, but I have to make a ruling as to relevance and whether or not it's going to come in. Whether or not it's collateral, whether or not there's a 352 problem. What's your authority that you're entitled to an ex parte show?
my I'm informed that the exact rule in this jurisdiction is 1054.7, and if I'm permitted to make a showing under 1054.7, I think I'll be able to connect it up with the court and indicate to you.
No, that doesn't go to offers of proof regarding impeachment. That's a discovery rule.
You have me at your dilemma here. Your Honor, what I'd like to do with the witness is show him these two segments that depict him and Miss Mazzola leaving Rockingham in the afternoon, and ask him which came first and which came second to lay a foundation for further impeachment. And if the court wants to know beyond that what that impeachment is, I would request the opportunity to tell you very briefly what it is at sidebar. This involves testimony of another witness. We haven't impeached yet.
All right, Mr. Goldberg?
Your Honor, you've made an objection that it's not logically relevant. That's number one. We are entitled to be heard on that objection. Counsel is entitled to make an offer of proof if he so chooses, or not if he so chooses. But we are entitled to be heard on his offer of proof and fully litigate the issue of this tape's admissibility. The people do have a right to a fair trial, too, and we also have the right to be heard. We have the right to be heard on this issue, and there are only a very limited number of exceptions in our state for in-camera hearings. There are in-camera hearings for Marsden motions, for certain discovery issues under 1054.7. For something that's work product, there would be an in-camera hearing, but this doesn't fall under any of the known exceptions. The second objection that we have is we have an objection on the issue of discovery, and I know we've gone over and over this, Your Honor, and we've talked about that famous Izazaga footnote. I think it was 5, probably the court remembers, that it talks about the obligation to turn over, not to turn over impeachment material. And it is my understanding that if the defense had gone out and talked to Mr. Fung and gotten an inconsistent statement from him, they don't have to turn that over to us. If they intended to call their investigator as a witness, they would probably have to put that investigator on the witness list. But this is not the type of impeachment material that is described in that footnote to Zaga. We are entitled to it. It is a tape, it is a piece of real evidence, and we are entitled to have it.
Mr. Scheck? Well, let me ask one further question. Mr. Goldberg, let's assume that you're entitled to have it. All right, let's assume I agree that you're entitled to have it since a videotape would be considered real evidence.
The only representation that we have from counsel as to how this videotape came into being or into their possession is that he was watching television, I guess, or looking at the videos in his hotel room and saw it. And we have nothing in the way.
No, let's assume for the sake of this argument, I agree with you that it's real evidence, that a videotape is quote unquote real evidence, not a witness statement per se. In this context, where it is similar to a picture because it depicts actions by Mr. Fung and Ms. Mazzola at Rockingham, apparently on June 13th. Apparently. Could have been the 28th. I don't know.
And is the court's question, assuming that there is a discovery violation?
Let's assume there's
what is the remedy, or?
No, what are you asking for?
Well, that it not be used at this point. I mean, that we have the tape provided to us, that we have an opportunity to determine for sure what date this occurred on, whether there are any other sequences on the tape that would indicate when in a chronological sequence the events depicted thereon appeared. That is why we have a discovery statute.
Mm-hmm.
I'm not saying that the tape would necessarily be precluded, because we know that preclusion is usually a remedy of last resort for the court,
Mm-hmm.
and is something that we can rarely legitimately ask for.
What
But
is
there
your
are-
what is your objection to Mr. Scheck showing Mr. Fung these two videotape items and asking which occurred first, walking out with your catalog case or walking out empty-handed?
What is the relevance? That is our first objection. And the second objection was a objection on the discovery statute. And just to briefly restate, we were saying that we are entitled to be heard as to that first objection, relevance.
All right.
In terms of the relevance, I really want to determine from the witness which happened first. In examining the tapes, I've tried to reconstruct it based on what I see and based what my understandings of the evidence are, but I won't know till the witness tells me. And I want to review this with him to try to do the best I can to reconstruct the events of that day and to probe whether or not he really received the blood vial on the afternoon of June 13th. That's where I'm going with this. I think I should be entitled to show those tapes to the witness, inquire of him which happened first, which happened second, and then conduct further inquiry as to whether or not these tapes are, and further explore the credibility of his answers.
All right. What about our discovery problem that the prosecution hasn't seen this, and I agree that it's probably real evidence?
Well, Your Honor, it's my understanding that I would be allowed to withhold this as impeachment material. That's my understanding. These sequences are on the earlier tapes, but from different angles. And in fact,
When did you get these items?
well, I actually got this item about a week ago.
Which item?
The second tape that showed Mr. Fung walking out empty-handed and Ms. Mazzola with the trash bag. And I had recalled seeing something on the television, and when we reviewed this tape, we didn't review it to the very end, and we didn't see it, frankly, until last night, that the full segment was there. We've made efforts to obtain another tape that we think has even more of this footage, and I've not yet viewed that tape, but I understand that we're making efforts to find it. So we're trying to get all the footage we can of what happened, and I'm trying to show the witness the best I could.
And when did you get those items?
Which items?
This last tape.
Well, this
Which is
last
actually
tape,
the first tape.
the first tape I think has been, I think the prosecution has that. the one of them initially coming out, I think has been seen before.
What we assume is initially coming out with the catalog case, correct?
Well, I don't know till I ask him which happened first and which happened second. I have a suspicion
All right.
based on his testimony.
Mr. Goldberg, do you have that first segment?
You know, I've seen segments like this, but I don't think I've seen this segment. And the problem that I have with counsel's representation, and I'm not trying to say this as any kind of an insult or pejoratively, is that when they represented to us that we had the videotape depicting what they claim to be the envelope, apparently we do not have that, the envelope that was supposedly passed to Mr. Fung. And Mr. Fairtlow did a very extensive review of our tapes last night and says he does not find them. And I provided him with the counter on that item, and we just don't have it. So I don't think that I can be comfortable that we have this simply because counsel has represented that we do.
As far as the last thing that Mr. Goldberg said, I'm informed by Mr. Blazer, who was the one that was dealing with this at the beginning of the trial, that the segments concerning the envelope and the glove that this witness was confronted with are on that KCBS tape, as we informed them yesterday, that I think is in evidence. So that I think
Well,
that's
that's another issue.
That's another, well, he braced it. Your Honor, looking at the tape, we did receive this particular tape, which depicts Van Adder testifying and Mr. Fung and Ms. Mazzola walking out on April 5th. But we only saw the first segment. And last night, when we ran it to the very end, I saw the full segment, which I did recall seeing when Mr. Van Adder was testifying, but we couldn't locate it
All right.
in its entirety.
We'll do this. I'm going to allow the prosecution overnight, since we're going to break with the jury today at 4 o'clock. I'm going to allow them overnight to review these tape segments to see if they feel that there's any prejudice to them in the disclosure. At this point, Mr. Scheck, I would imagine you have enough to go on and fill the afternoon.
Well, actually, to be frank, Your Honor, this was...
This is it?
This is the issue of the turnover of this blood vial is the last line of cross-examination that I have. I must say, Your Honor, until I know exactly what the witness says with respect to these tapes and which segment is first and which segment is second, I won't be able to proceed to the very end because it's dependent on his answers.
All right. Mr. Goldberg, does that sound acceptable to you? You have some opportunity to review the tapes, compare them with what you have, and we'll proceed tomorrow morning with continuing with Mr. Fung.
That sounds like it would be acceptable, Your Honor. May I just have a moment?
It's not like I don't have other things to do this afternoon.
Okay, Your Honor, there are a couple other legal issues that I did want an opportunity to address. One was as to the tape that I just mentioned, and the other was as to the phenolphthalein issue, which I think needs to be revisited in light of the cross-examination. I don't know whether the court would like to do that now or at some later point.
All right. My inclination would be to recess as far as the jury is concerned right now. Come back in 15 minutes and discuss these other legal issues, and then commence our other hearing. At 4 o'clock. And I anticipate being in session till about 6 on that. So we still have a full day ahead of us.
May I make one quick request that may save some time?
Sure.
May I ask permission to bring the witness back before we break and simply inquire of him without showing him any tapes, just through verbal description, if he recalls the events and which happened first?
All right. That seems reasonable, without the display of the videotape. All right. I'm sorry, you need it right now? All right. Do you need to change paper? Okay. Court reporter needs 5 minutes. Don't go away. All right, let me change give the court reporter a break. All right, let's take 5 minutes for the, well, we're so close, let's just take our 15 at this point. All right, 15.
Ask an instruction that they not discuss this last matter with Mr. Fung.
Yeah. Today, and I was hoping to finish Mr. Fung this afternoon. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Do not allow anybody to communicate with you. Do not conduct any deliberations till the matter has been submitted to you. And I know you have some activities for the evening, so I'm sure you're not too unhappy to get started earlier today. All right, we'll stand in recess as far as the jury is concerned until 9 o'clock tomorrow morning. And we will, as soon as the jury has been excused, we'll take up some of the other legal issues we need to discuss, and then we'll start our 4 o'clock session at 4 o'clock. All right, thank you, ladies and gentlemen. Back on the record in the Simpson matter. Mr. Goldberg, you wanted to raise an issue regarding phenolphthalein testing?
Yes, Your Honor. I thought the court had ruled that phenolphthalein was not going to be admissible, and then it became my understanding perhaps the court had ruled that positive tests were not admissible, but negative tests were.
That's correct.
The defense has now clearly introduced a positive phenolphthalein test without any prior approaching of Your Honor and trying to get a modification or clarification of the court's ruling, and it seems to be clearly in violation of what the court's ruling was. Aside from that, we also have the issue of the court having said that in terms of your phenolphthalein ruling, that you would not allow the defense in any way to place before the jury information or evidence that would be misleading in terms of negative results in certain locations, creating the inference that there was no blood in those locations. The defense put in evidence that there was a negative reaction in the sink drain, sink trap. And we know that, of course, we have a positive phenolphthalein test in the drain part of it. This clearly, without any doubt, creates an entirely erroneous picture, because it's almost as if you're telling the jury that this little spot over here was tested for phenolphthalein and it came back negative, when we know that the little spot next to it came back positive, and then arguing to the jury that there was no blood there. And what the defense has done is they have tried to create a change in what Evidence Code Section 352 is really intended to do.
Well, isn't your argument that the court's ruling was that no positive results of phenolphthalein testing would be admitted unless there was some backup or subsequent testing to confirm that, since phenolphthalein is a presumptive test only. However, that the state of the science is that a negative phenolphthalein was pretty much conclusive in and of itself that blood was not existent. So that was the state of the court's ruling. Then, during the course of the cross-examination of Mr. Fung this morning, I noted that the defense then offered through Mr. Fung positive phenolphthalein testing that had not been confirmed by any other testing method. So having made the initial objection and then sought to themselves to introduce it, then your argument is probably that the prosecution's entitled to do likewise, correct?
Yes.
All right. Mr. Blazer?
Yes, Your Honor. Our purpose in asking that question of Mr. Fung, it's our position that that never happened, that test never happened. His testimony was that he had been sent back specifically to do testing on July 6th, I believe it was, and that he claimed that he went back and did that, but didn't tell anybody about it, didn't record it anywhere, didn't write a report until October sometime, where he then includes what he maintains was the test results. We did not ask that for purposes of establishing that there was a positive pheno test. We used it for impeachment purposes to show that that never happened. And it was not our intent to open up all other pheno testing positive results for admission as positive evidence of blood.
Well, isn't that, first of all, it's inconsistent with your previous position that I did grant your motion to restrict that use, the use of positive phenolphthalein testing without any backup, and then to broach that without asking for any limiting understanding with regards to that, or couching it in some other way, presumptive test, without mentioning phenolphthalein or anything else. Haven't you created a conflict, and is it now fair for the prosecution to bring this evidence in?
Well, I might point out there was no objection at the time that question was asked.
Well, I know there was no objection. I mean, they were probably hoping, I mean, I saw wide eyes over on this side of the table is what I saw.
Well, again, this was for purposes of impeachment of Mr. Fung. We don't believe that that test was ever done. It was evidence that he was purporting to have created for purposes of demonstrating that he did something on the 6th, which we don't think he did. And it's
But
our...
couldn't it have been couched in terms of an unnamed test, presumptive test for the presence of blood or some other way? I mean, couldn't it, and shouldn't you have given notice to the prosecution you were about to do that by asking to approach?
Well, may I have a mention? We had talked about, at a bench conference, about asking the question pertaining to the test of the sink trap, and I believe you were aware of that and had okayed that particular question. We chose not to do that with this impeachment material of Mr. Fung. We are very hesitant to reveal our impeachment material before we use it on the witness. That's the whole purpose of impeachment material. And perhaps we should have done that. We didn't do that. It certainly was not our...
It wasn't really true impeachment material in the sense that it was unknown and that there was some surprise advantage since you already had the transcripts in his testimony previously.
Well, I don't think there had been any testimony before about the fact that he did not write a report until October 6th, I believe it was. Mm-hmm. And it's our position that that delay of many months was a cover-up, to cover up the fact that, to cover his testimony in October because he had not done anything in July and that nothing was done, no testing was done. It's been our position all along with respect to Mr. Fung that this never happened. And I think it was appropriate impeachment material along those lines. If they want to ask him questions about it on redirect, I'm certain they'd be allowed to do that. But I don't think that that opens the door to all other pheno testing in other situations with other pieces of evidence.
Why not?
Well, because I don't think it does, because it was for a limited purpose of
But see, you didn't
impeachment.
ask me to limit the purpose. That was just general evidence that was just brought before the jury.
Well,
You didn't give the court notice. You didn't notify the other side because I had ruled in your favor, and then you go in and bring in something you asked me to keep out. So now it's out there for general purpose. There's been no advice to the court that I should give a limiting instruction to the jury. So isn't the door wide open at this point?
We have no objection to a limiting instruction. I think one was given before on this very issue. I may be wrong about that, but that's my recollection. But we have no objection to your advising the jury exactly what the nature of the test is, and that it's a presumptive test, and that this was a question that was asked for purposes of impeachment only.
All right, Mr. Goldberg, any other comment?
Your Honor, I don't want to take up more time with this than the court feels is necessary, particularly if you're inclined to rule in our favor.
Don't assume that.
Okay, well, maybe I will take up some more time.
No, I mean, let me ask you this. Do you have any case law? Because the case law, say, for example, in other presumptive tests, indicate pretty much what the court's ruling has been, that unless there's a 352 issue, and there are a lot of courts that have kept it out on that basis. Do you know of any other reported case that deals with a situation similar to ours?
Where they open the door by introducing presumptive testing of one test? No, I haven't, Your Honor, but we do know of the rule of curative admissibility that are commonly referred to as opening the door, where one side puts in evidence, the other side is entitled to rebut it. And let me point out the fallacy of counsel's argument is that there was no reason whatsoever that they had to ask what the results of the phenolphthalein test. There was no reason, as the court points out, that they had to ask what the nature of the test was specifically. Their alleged reason for doing it was simply to show that he had claimed to have done a test, but the result has no impeachment value whatsoever if they're trying to characterize it as impeachment or attacking the credibility of the witness. So the argument that they're making simply falls on that score. But I'd like to make two other arguments that I feel are also very important. Number one, the court, I think, was ruling under 352 of the evidence code at the time that Your Honor made its initial ruling. And what the court said is you said that you would not allow evidence to be put before this jury in such a way so that it were misleading. What we have is a situation where the defense has very extensively asked questions as to how much blood was in the Rockingham location, as to where it was, and very specifically asked whether the sink trap was tested and what the result was, and that it came back negative. Now, what earthly reason is there for asking that question other than to be able to argue to this jury that there was no blood in the sink and that he did not wash up in the sink? There is no other purpose for doing that. So how can you possibly allow a situation under 352 where they've been permitted to introduce evidence that there was a negative phenolphthalein in the sink trap when we know that there was a positive test in the sink drain itself? That is misleading. I think that what the defense is doing is they are trying to have the court convert 352 from a shield that's designed to protect you from overly prejudicial evidence into a sword that's designed to create an inference that there was no blood in these locations, when in fact we have a scientific test that says that there is. Your Honor, I would say on the score that if the court thinks that we need further foundation in terms of a serologist, we could conceivably have Mr. Fung simply testify to what he did in the color change in his observations and have someone else testify to the interpretation, although I don't think that step is actually necessary. So there is more than one reason for allowing this in. Opening the door is one, but fairness is another, and a proper usage of 352 is another. And this case should not be submitted to the jury in the posture that there is no blood and no evidence of blood when we know in fact that there is, and there is a reliable test that is used in the scientific community that suggests that. Also, I'd point out to the court that we did find out from technical experts that bleach does not cause a false positive with the phenolphthalein test when you use the two-stage method, which I speculated was the case, but now has been confirmed to be the case by experts that we have spoken with. May I just one moment? As to the first argument, it's also too late for a limiting instruction at this point. It came in for all purposes. Jury's not going to be back until tomorrow. And finally, I'd like to point out one other thing. In rehabilitating this issue, or readdressing this issue with Mr. Fung, we need to show what his practice is with respect to what he does when he gets a positive phenolphthalein test, or when he does a phenolphthalein test in general, because we can show that he does not write reports contemporaneously, an analyzed evidence report contemporaneously with that testing. He didn't do it when he tested the Bentley, so we need to get that in. He didn't do it when he tested certain other items at Rockingham, including the sink and the shower. He did not write an analyzed evidence report. So we need to show what this man's practice is and that it has been consistent throughout this case, and that is of vital concern to the people in addressing the supposedly limited issue that counsel says that the phenolphthalein test was introduced on.
That's exactly the point why it was important that he be asked the question about the pheno test being positive as opposed to being negative. We were not asking that question for purposes of eliciting the truth of the fact of what the pheno test was, but the fact that he said it was positive makes it a much more important event, one which he would record, tell his boss, tell Ms. Clark, tell somebody, than if it had been a negative test. So that particular piece of information was not offered for the truth of the matter stated. Far from it. It was offered for just the opposite, to show that by his testimony, that would be the important type of event that he would record. I'm not aware of any case authority on opening up the door with this kind of a question that opens up a whole scientific area as far as testing in other realms. And if the court is concerned about that, if the prosecution has any cases they want to cite, we'd like a chance to respond to those.
All right. Thank you, counsel. All right, I'm going to do a little more research on my own with regards to this particular issue, because I think the landscape of the issue has changed considerably since this morning. I felt very comfortable with the initial court ruling, but now that we have a different situation, I'm not so comfortable with it anymore. So I'll take a look at it over the evening hours.
Would the court want any testimony on this issue as to the phenolphthalein test?
No, I don't need that. The issue is whether or not the court having ruled one way at the request of one party, and then that party having decided to bring in that very thing, whether or not in fairness you're entitled to do the same thing. That's the issue. And within the rubric of 352. So I'll take a look. All right, any other legal conundrums you want to present to me?
There was another issue as to the videotape, Your Honor. Apparently, we did not get the exact copy of the videotape that was shown to the jury, the one with the counter in it, and the one that we have, according to Mr. Fairtlow, and I can't represent this on my own, is not shot from the same camera. May I just have one moment? They are the same, except that one has a counter on it and the other doesn't. So apparently one is edited and the other is not. And we would like the exact same version, because there may be a difference in quality or clarity, which would resolve the issue that was raised as to exactly what item was being handed.
All right, Mr. Glazier, do you have any problem searching your videotape file, making available to the prosecution the same exact footage with the counter in it rather than the counter removed?
They already have it, Your Honor. Mr. Fairtlow could not find the clip with the envelope and the glove on the blanket. He said he went over the tape in great length. I showed it where it was on the tape, and I think he's satisfied that at least those clips are on there. The clip for the counter are on there someplace as well. We've given him that tape. I think it's also on the first tape that we introduced, which is Courts Exhibit number 2. I think that's the same tape. But we've given them that tape at least twice, and it's on there.
All right, you're saying that's on Courts Exhibit 2?
I think that's the KCBS tape that we had introduced very early on. Whether that has the one with the counter on it, I'm not sure. There are a lot of clips. There's probably 7 hours of tapes that we've given them. That's a compilation of 7 tapes, which we'd also given them. And there are a lot of repeats, a lot of repeat clips, and we made those excerpts from that 2-volume set. So, and we didn't do any editing ourselves, other than to take the clips out.
All right. Well, it seems to me if it's the same footage, then there's no additional need. I know that Ms. Hazlett is still searching for the original format of that particular tape so we can see if it's available for enhancement purposes. And if we locate that from the news media, I'll let both parties know as soon as we do. All right, I see it as a non-issue at this point. All right, anything else before we launch into our 4 o'clock matters?
Yeah, I think one thing we said, we set the date for the motion and we had filed, it was set this afternoon, and at your convenience, you can just tell us what's a good date for that. There was another 4 o'clock meeting that you'll
Yes,
have
I know.
at your discretion do.
Yes, well, I'll tell you what, let's see where our 4 o'clock hearing today takes us
I see.
time-wise, because it's extraneous to the presentation of evidence to the jury, and I want to see what kind of time obligations I'm going to have to spend with that issue before I commit to a hearing on the other issue.
That's fine.
All right,
Which motion is council referring to?
referring
The
to,
prosecutorial misconduct motion that was set at 4 o'clock today. And
Which prosecutorial misconduct motion?
Choose either one.
I think it's in volume 2. Okay, anything else before we await the parties for the 4 o'clock matter? All right, for the news media information, I normally conduct my jury inquiries in chambers. I will make a transcript of the proceedings available to you as soon as the transcript's available for today's proceedings, probably first thing tomorrow morning.
The jury,
Yes, sir.
regarding Mr. Simpson. Mr. Simpson has expressed a desire, Your Honor, to be present, and I know the court's ruling with regard to chambers, but he would like to be present for any hearings regarding the jurors from this point forward, and I'd ask the court to consider that. Perhaps we can do it in the courtroom with him out here, perhaps.
As far as non-jurors are concerned, I'll grant that request. As far as jurors are concerned, I'll decline that request. Those inquiries will be conducted in chambers with counsel present on the record, without the presence of the defendant.
All right, thank you.
Non-juror witnesses will be interviewed in his presence. Right. Including non-jurors includes ex-jurors. You're welcome. Okay. All right, we'll await the arrival for the parties for the 4 o'clock matter. All right, thank you, counsel.
Thank you.